Good morning, members. Welcome back to the committee stage of the Employment Leave Bill. Before I give the call, I'd like to clarify a ruling that I made last night about the grouping of amendments. I've had time to reflect on the decision to group amendments in the name of two Green Party members. Actually, I think there were three. There were three Green Party members under Standing Order 3153. This gives the chairperson discretion to group amendments if conditions are set out in paragraphs A to C are met. The conditions are the amendments stand in the name of the same member, the amendments lend themselves to being grouped on account of their content or subject matter, or they form a single alternative proposition. Grouping of the amendments is necessary to enable the committee's effective consideration of the bill. On reflection, and after considering the points made by members last night on the issue, it is clear now that all three conditions must be met to allow grouping rather than just one or two conditions. This is the correct interpretation of the standing orders based on Standing Orders Review Report of 2011 and Chapter 38 of Parliamentary Practice in New Zealand. In addition, I'd like to remind members that it is a long-standing custom of the House that members agree to a motion to recall the Speaker to rule on a disputed matter of procedure. So, Kieran McAnulty, point of order, Kieran McAnulty.
Thank you, Madam Chair. First of all, I want to thank you for that clarification. It is clear that this is, whilst it is a standing order that has been in place for some time, it is not one that has been used often.
Yeah, that's right.
And it is entirely understandable that as we work through this new approach, that there be a few wobbles.
Yep.
And so we certainly don't criticise presiding officers for that, and recognise the reflection that you've placed on that and the clarification that you have provided.
Thank you.
Last night I indicated that it was our intention to recall the Speaker, not to relitigate, but to provide clarity for the entire House's benefit, because we want to ensure that everybody knows the conditions under which the committee stage and amendments would be considered, keeping in mind that the Speaker's statement was just as relevant to government amendments submitted late as it was to opposition amendments to change the bill. Notwithstanding your clarification there, it is still my intention to seek that clarity from the Speaker. Having said that, given the detailed clarification that you have provided, keeping in mind that this is relatively new territory, it seems to me, listening to the statement you've just made, that that warrants a new Speaker's ruling. And so if I could, in the first instance, get clarification from you, or perhaps after referring with the clerks, that it would be considered such and included in Speaker's rulings moving forward, then there probably is no need to recall the Speaker. But if we're not in a position to provide that at this point, it's still my view that it would be best, not in no way at all undermining you, but to provide the clarity that the House quite clearly needs.
Yeah, just give me 1 minute. I'm happy to make that a new Speaker's ruling. A colon made a big difference, and that's where the misinterpretation was created. And so very happy to make that a new Speaker's ruling. Yeah.
Thank you for the clarification. On that basis, there's no need to recall the Speaker. I believe the House has the clarity that it sought.
Thank you. There was one other matter last night around the issue of any attempt to recall the Speaker, even be having leave refused or a vote to turn down, so that it makes it very difficult for any opposition to recall the Speaker. I'm very happy to go away and ask the Speaker to clarify that, because it's not much point having an option if nobody can ever, doesn't matter what side of the House people come from, everyone's in opposition at some time, and it's not a satisfactory arrangement that can happen, so we need to clarify that as well.
Speaking to that, thank you.
Honourable Kieran McAnulty.
Thank you, Madam Chair. That would be useful. It is a long-standing convention, and I can think of one instance so far in this Parliament where it has been voted down. We didn't pursue it at the time, But certainly in an instance like this, where it is quite clear that it is a genuine attempt to seek clarity, it was disappointing that wasn't followed through and the convention wasn't followed. I can think of one instance in the previous parliament where that was the case, and on reflection there was, I believe, an apology given because the wrong decision was made at the time. It would be good to get that clarity so that that convention is followed. It's a convention because it isn't a Speaker's ruling, and it isn't a Speaker's ruling because we don't want it abused at the other end either.
Well, yeah, and it's impossible. I mean, it's pointless if it's not possible.
Yeah, correct.
Yeah.
Thank you.
Okay, thank you. So members, when we suspended last evening, we were considering the Employment Leave Bill and we were debating Part 3. This is the debate on clauses 133 to 200, leave records, enforcement and other matters, and schedules 2, 3 and 4. The question is that Part 3 stand part, and just before I take a call, last night I found in Part 2 we were getting lots of speeches and not so many questions, so I'm really looking forward to your questions on Part 3. Thank you. Honourable Giantinetti.
Thank you, Madam Chair. I just want to highlight the questions that were asked right at the end last night, and we didn't have an opportunity to hear from the Minister to hear those answers. I believe that they were one from myself is what quantified advice did the Minister receive on additional resourcing for the Inspectorate, the payroll expertise and the funding required, because that was something that we felt was very important to this particular part. And the other question, I believe, came from my colleague, Honourable Phil Twyford, around what the Law Society had identified as the complexity and the clauses of 133 and 140, and what employee user testing shows the worker can audit hours, classifications, notional rosters, accruals, payments, and the leave compensation payment from the prescribed records. So that's just, I hope I got that right. That was me just clarifying a little bit.
Sounded good to me. Yeah. I was here last night, so it sounded, yeah.
Thank you. Yep.
Honourable Minister.
Thank you, Madam Chair. Happy to make a start this morning. So in response to Giantinetti's queries about clause 133 about the record keeping requirements and the Labour Inspectorate, priority while creating this bill was to give simplicity while ensuring employers keep information needed to demonstrate their compliance with the law. This overall will make it easier for the Labour inspectors to carry out their core work, and MB will have guidance on hand to support the Labour inspectors. The Holidays Act, being the current law, has created a lot of work for the Labour Inspectorate through its complexity, and so a simpler system will help. The Honourable Phil Twyford asked last night about how we can be sure that employees can understand and use the record keeping requirements. And the first goal of the requirements under this law is to ensure that employers keep the information that they need to be able to show their compliance, while the bill itself creates a new requirement for employers to give a pay statement every pay period, which must include key information employees need to understand and track their leave entitlements. And I see that as a great improvement over the current law, that all employees will actually have access to their own leave pay statements.
Honourable Giantinetti.
Madam Chair, and just quickly following up then on that, what advice did the Minister receive, if any, on reversing the evidential burden where an employer fails to keep accurate records? Because I think that that is a pretty important part of this, is ensuring that. There's something else that comes in this particular part or subpart that I think is really important, and that is what is disclosed on the pay statement. So will each hour of it, will every pay statement disclose each hour category, its leave consequence, the leave compensation payment rate and the notional roster used? Because I think, again, this is where we need some clarity around that from this particular part. If not, how can the right be enforced in practice? So if that's not the case that it's going to be on there, how is that enforcement going to look in practice? So there's two questions there.
Te Anō Tuiono.
Yeah, Madam Chair, I am interested in how the notional roster will work, and I was wondering if the Minister could step us through that. It is a new part that has been introduced into this legislation, and I know that will create the need for new processes. So I was wondering if the Minister could step us in terms of the way that those records.
The member just quote the clause number for my purposes. Thank you.
133 leave records. And so with the notional roster, which is the new element introduced in an earlier part, that should form part of the leave record, but I'm not too sure how that would play out. So getting some clarity around that would be good. And also a bit more detail on how the Labour Inspectorate will be resourced as well. We did have a bit of this discussion in the previous part around concerns that if you're going to have, for example, multi-role agreements and a number of different agreements at particular work sites, well then that can create a burden, particularly if there's a dispute between employers and employees, and because of that, that could create extra burden. So what analysis has the Minister done with officials to determine whether the resourcing is actually even there to comply with that? So if I could get some answers to that would be good.
Honourable Minister.
Yeah, look, very happy to take that last part. I believe I'd have touched on the essence of part of the last portion of that contribution in response to Jan Tinetti in regards to the fact that the bill itself will simplify the law and therefore it will actually make the job of the Labour Inspectorate easier than the current status quo. But in regards to the specificity of the questions from both members regarding the notional roster as well as what's specifically on the leave form, I will wait for the advice from officials.
Okay, thank you. Honourable Jan Tinetti.
Yeah, sorry about that. I was just looking for the particular part, and it was one that had come up in the submissions that we heard at Select Committee. And I think that it specifically is in relationship to clause 1363. And I'm trying to keep this very short here, but I just want to sort of put a tiny bit of context around it, Madam Chair, so that we understand what the question, where the question's coming from. The Law Society considered that the intent of clause 1363 was unclear and recommended clarifying in the bill whether this is intended to bar an application for non-party disclosure under Section 24 of the Criminal Disclosure Act 2008. They considered that as drafted that it would have the effect where the defendant is seeking disclosure of family violence that it would be a negative effect, and I note that the Select Committee recommended the changes to that. The question that I had when I read through those changes, is the Minister comfortable that this addresses those issues? Because I remember at the time thinking that this could be have quite a big impact, and so I just want to know that the Minister is and why the Minister feels that this particular change that has been made is going to address the concerns that came through from the Law Society. So just probably a pretty simple question, but just thought we'd put that in there.
Yes.
Honourable Minister.
Look, happy to take that last portion in regards to clause 136, and I acknowledge that the Select Committee did make a change to the law here in regards to the requests for access to leave records to make it clearer that an employer may only provide a representative of a union access to an employee's leave records if the employee has authorised them to do so. And I think that's the point that the member is raising, that it's quite important where you have quite sensitive information that you may not wish other people to have in their possession, that it is actually up to the employee to give authorisation. I am comfortable with where this has landed, especially because this clause does not affect any obligation on an employer to disclose information as required under the Criminal Disclosure Act. So I thank the member for that contribution. The member also asked, what does enforcement look like in practice if records aren't kept? And the bill provides for a graduated enforcement approach. It does create an infringement offence which could be used by the labour inspectors as a spot fine if records cannot be produced. The member also asked whether or not we'd considered reversing the evidential burden where improper records are kept, and the bill retains the status quo where employers are liable for a penalty if improper records are kept. So nothing controversial there in terms of keeping parts of the current law into the future law. Tiana Tuiono asked for a little bit more information about the Labour Inspectorate resourcing, and I am quite confident that the Labour Inspectorate is well resourced. As always, though, that they do prioritise their interventions based on potentials for harm, and under this government, the member may wish to note that we have actually increased the resourcing for the Labour Inspectorate.
Madam Chair. Thank you, Madam Chair. If I could draw the Minister's attention to Clause 134, leave records forms, and I did note the Minister was talking, and I think it's a good point that actually these records must be in good nick and easily to be accessed so that people can make the determination about what was agreed to, what wasn't agreed to. But I was wondering around some more context around 1341B. And so in A, it's the leave record must be kept in written form. That's fairly standard. Those of us that remember the 80s and 90s, that was the only kind of way that you would keep your record, your leave record kept. But B, it goes in a form or in a manner that allows information in the record to be easily accessed, which is good, and converted into a written form. So I was wondering, in this digital age where you have employers and employees sort of texting each other, if you will, whether that extends to text messages, whether that extends to screenshots of and chats, etc., and I think it's an important thing to note because that will, if it ends up becoming in the middle of a disagreement between employers and employees, could be an important thing to point, well, actually what was agreed to, particularly when if they're potentially discussing the bits and pieces of a notional roster and you've got an employee who thinks, well, actually, I've got 3 standard hours, but in case of the retail worker we've been talking about last night, but actually I should have 20 hours because that is the recognised working pattern, and perhaps only the way that they could get that agreement is via this text message or via the screenshot as well. So if the Minister could help us to understand what that particular bit means in the context of the digital age, that would be good.
Yes.
Honourable Minister.
Thank you, Madam Chair. Happy to give this one a go. Look, 134 is talking about leave records being kept in either a written form or in a manner that allows the information in the record to be easily accessed and converted into a written form. I think the essence behind this clause really is about access to information. You're right, in the old days, I think people might have done a lot of their timekeeping by hand. Nowadays, a lot of that is modernised and put on different systems. It's really allowing for the flexibility of being able to convert what can be quite complex calculations really into being able to write them down. So it's just allowing for flexibility in the modern age.
Yeah, I looking at your face, you're looking for a clarification?
Yeah. Because if he follows down to the leave records retention bits, I'm just sort of AI data centres are on the mind, Madam Chair, and I was looking at being able to keep information on a leave record for not less than 6 years after the date on which the information is entered, under which, how exactly, what would be the acceptable forms in terms of that retention of data, given that data is so easily deleted, or you unplug the wrong thing and next thing you know it's gone. So I'm wondering about the impact of that, given the limitations of digital data storage. So I was wondering if the Minister could give us a bit more information on that aspect.
Minister's just asking which clause you're referring to.
That's 135, leave records retention. So 1351 is an employer must keep information that is on a leave record for not less than 6 years after the date on which the information is entered. Fine if it's on on some paper, you can put it into a filing cabinet. But if it's sitting on a USB or on a computer, and then that computer gets lost or plugged into the cloud somewhere, and there's some kind of issue because there's not enough water to keep the data centre cool, then that could become a problem. So I was wondering if the Minister has done any analysis on that particular aspect.
Honourable Minister.
Look, I haven't done any specific analysis on the data storage in relation to this bill, but I think the important point is that it is a legal obligation for companies, not just with Holidays Act, but with a range of different compliance standards under the law, to keep accurate records for those for a period of time. And for this particular law in particular, it becomes quite clear that if there has been an issue of non-compliance, this allows a period of time for those records to be looked at and to be analysed to ensure that they have actually complied with the law. But it is up to companies how they ultimately store their own data, or whether or not they do still wish to do it in traditional filing cabinets in the HR department.
Honourable Giantinetti.
Thank you, Madam Chair. I want to move to clauses 152 to 158 and Schedule 3, which is regulations and historical remediation, noting that I'm not sure where my colleague is moving to over there. So, yeah.
No, that's okay. I can work with that.
Yeah, okay, great. So the issue around this particular part is that employers may opt into a regulation-based process to settle historical Holidays Act liabilities. The government has said that it's optional. The standardised process offers employees faster payment and employers legal certainty. So we see that the committee safeguards are improvements that came through in this particular area, but do not, and this is the concern that we have on this side, is that they do not answer the constitutional and fairness concerns. We particularly noted again, and I know that this has come up a few times from the submission, but the Law Society said that the substantive process lacks transparency and retrospective rules may affect settled expectations. So on that note then, what constitutional, if any, advice did the Minister receive on delegating the calculation method while asking Parliament now to authorise that extinguishment? I'm trying to keep this short, so I hope there's enough context around that.
That's right. Thank you. While I wait for specific advice on that query, I will touch on Tiano Tuiono's query in greater length about the information that needs to be kept for the 6 years. So, interestingly enough, this is a carryover from the status quo. In the Holidays Act, it does require under the law for information to be kept in any form. The Contract and Commercial Law Act defines written form as including electronic means. However, the onus is always on the employer to keep the information for 6 years.
Yeah, Honourable Giantinetti.
Thank you. And carrying on in the same vein, and I'm only going to keep a question at a time again to keep it short, but also to give the Minister the time to get the answers to that. The departmental disclosure says that the remediation design was not covered in detail. Design was not covered in detail by the RIS and was exempt because it was developed under the delegated authority. How can the Parliament, and I'm looking for the Minister's how comfortable she feels that the Parliament can assess proportionality when the core methodology has had no published regulatory impact analysis? That is something that actually stood out for a couple of the submitters, but also me around this when we were looking at this in depth, around the fact that we hadn't had that regulatory analysis around that. So want to make sure how the Minister has assessed that Parliament, how Parliament can assess that proportionality, because we didn't have that regulatory impact over the core methodology. So hope, again, there's enough context.
Honourable Minister.
Could I ask for a little bit of clarity? Is this in regards to, is it clause 156?
Yeah, just let me go to that. It was in that. Yes. Yeah.
Oh, great. Yes, so I'll do my best to help the member through this part, but the regulations that could be produced for a remediation process have not yet been made, and so there would not be anything for any regulatory impact statement to analyse yet, because nothing has actually been done from my side as the Minister, yet not from the official side either. Now, once the law itself is passed, I'm very hopeful that the regulations will be made with a lot of fulsome detail, but unfortunately we don't have that information at hand yet. However, the point to really note is that the remediation process set out in 156 doesn't exist unless a remediation process is actually made, and at this point in time there is not yet one. This is simply allowing for one to be made in future.
Just in time, Mr. Toiono.
Yeah,
Toiono.
It's a slow morning, Madam Chair.
I was just about to take a vote, so you're very lucky.
Yeah, just on the, I was just thinking about what the Minister was saying around the record keeping bit as well, and I wanted to know what those changes mean in terms of the digital storage aspect, in terms of notional rosters. It seems to me with this as a new element that can create, in order for, let's say there's a dispute between an employer and employee around exactly what are the conditions of a notional roster. It would seem to me that in order for the Labour Inspector to really get a very clear picture of actually what was agreed, that they would need to look at digital records both from the employer and employee to actually confirm what was actually agreed to be in that leave record. It is a new aspect which was introduced in this legislation. So I'm wondering how, in terms of the retention of those leave records, is it just what they believe that they agreed on, or the communications following up to the agreements, which would give a clearer picture of what was agreed on? So there's two kind of things to sort of really get a clear picture of what that national roster would look like in terms of digital storage.
Thank you.
Honourable Minister.
Thank you, Madam Chair. In further regard to the query from Jan Tanetti about the remediation process and what constitutional advice did I receive about the regulations, I did receive advice from MB on the appropriate ways to design legislation. Importantly, though, the primary legislation is used to authorise the legal effect on employees' claims under the Holidays Act, but I'm satisfied it is appropriate to use regulations to set out the technical calculations. But as I acknowledged before, those technical calculations have yet to be written.
Honourable Phil Twyford.
So further on the remediation process, it's obviously very difficult to scrutinise that properly, given that it's yet to be drafted or presented to the Parliament. But what we do know is that the proposed framework won't require the consent of workers. It may extinguish some workers' ability to claim, and it may permanently suspend claims that are before the authority. So in light of that, I'm interested in what advice the Minister received about the extent to which that may be in conflict with the right to justice provisions under the Bill of Rights. I'm also mindful, as the CTU submitted at the committee, that that workers under these provisions may receive less than their legal entitlement, and may in fact may happen in a situation where they are not even contacted. That's a potential scenario. So yeah, and I suppose the question is what evidence justifies extinguishing an employee's own chosen course of action without their agreement.
Honourable Minister.
In follow-up to the Honourable Jan Tinetti's contribution about proportionality of the remediation process, there are safeguards built into the law. The Minister must have regard to data from remediations and must consult with employer and employee representatives before making the regulations.
Honourable Jan Tinetti.
Thank you, Madam Chair. Actually, not in relationship to the answer to that one, but the answer from the previous question around the draft regulations of the remediation process and not having that impact analysis. And I totally understand that because it hasn't been written, so you haven't been able to do the RIS. Is there a commitment that there will be a full impact analysis on that? And also so that people understand it, that there will be worked employees examples, so that particularly employees will understand what it might look like for them, and you know, at some stage maybe referring even to a select committee before an employer may opt in, because at the moment we haven't seen that, we can't see it. And that's where there's a little bit of a bone of contention, and it came through from some submitters as well. And as this side of the House, we do have a level of discomfort at the moment because we can't see it.
Honourable Minister.
Thank you. So in relation to Honourable Phil Twyford's contribution about the remediation process and whether or not it's in conflict with the Bill of Rights, the Minister must be satisfied the remediation process will result in reasonable compensation that is put into the law. The Bill of Rights Act VET identified no inconsistencies with BORA in the bill.
Honourable Phil Twyford.
Why is it, through you, Madam Chair, why is it, Minister, that only the employer is given the ability to elect the remediation process? Why not the other party in this dispute, the employee?
Honourable Minister.
Right. So in regards to Tiana Tuiono's earlier contribution about the record-keeping changes, and what does that mean in terms of the digital storage of the notional roster in particular, Clause 9 provides that notional rosters must be agreed in writing when entering an employment agreement. Writing extends to digital form. They must be kept up to date, and therefore they must always be on record for use during employment.
Honourable Jan Tinetti.
Chair, and just probably my final question on this particular part, although I do have some questions after that, but not many. This particular part, there was during our submissions, and I have gone back and had a really good look at them around CTU and NZNO, the nurses organisation, warned that workers may receive less than their legal entitlement, or may never be contacted about that. I'm quite interested to know what evidence supports reasonable compensation rather than full legal entitlement, and as it says there, and what expected underpayment range was modelled, because that's what we again have a level of discomfort about, because we don't know what was actually modelled in that expected underpayment range. So very quickly, last question.
As I wait for some very specific advice from officials, I will tick off what I think is the high-level concern that the member has, which is that the Minister does need to be satisfied that the remediation process will result in reasonable compensation before signing off these regulations under the law. But importantly, through the detail where we work to find out the specific detailed calculations that could make up a remediation process, the Minister must have regard to data from remediations, and I guess that means that remediations of the past that have occurred in practice or real-world examples that are not, so it's not that the Minister just picks a number and says, this is what I believe to be reasonable compensation. It will be actually based around previous and historic remediation cases, which shows that there has been a level of satisfaction from both parties in previous real-life examples, that people have actually been comfortable with where reasonable compensation has landed.
Te Anō Triona.
Chair, I just wanted to sort of check with the Minister that I mean, if I heard it correctly, that this bill is consistent with the Bill of Rights, and if it is consistent with the Bill of Rights, there was the other question around whether an impact assessment could be done, because we don't know what the outcomes of this whole bill is. So the satisfaction for this bill being compliant with the Bill of Rights on the face of it might be evident right now, but if without an impact analysis to determine the actual impacts of this on workers, I think is an important point to make, because as has been reported in the media, people are saying, there is reports out there that this will negatively impact 200,000 workers, and if 200,000 workers are losing holiday pay, the ability to take sick leave, bereavement leave, etc., then I think that warrants an analysis to be done to make sure that this is actually compliant. What I'm saying is that it's important to give it another look. That is an incredibly large number of people, if it's correct, and having that analysis to check to see whether those numbers are actually correct, I think would be due diligence. I think that's an important point that was made by my colleagues just to the side of me as well, and I think it would be good to get some commitment from the Minister that will happen.
Honourable Minister. In regards to the contribution from the Honourable Phil Twyford, he asked about what evidence justified removing an employee's chosen course of action as opposed to the employer's chosen course of action. And the objective of the new legislation process is to provide a faster way for all parties to achieve certainty. I'm sure the member will be aware that there are a number of cases that have happened. I won't go into detail on them, but a number of cases where people are still waiting to be paid because the remediation process has become so lengthy and drawn out and has taken such a long number of years. And I certainly hope that the member would appreciate that. I'm sure some members of the community who have been underpaid and are waiting for remediation would be very happy for a faster process to happen so they get money back that they were due. Allowing claims to be made under the Holidays Act, though, in parallel with the remediation process here, would create uncertainty and potentially for quite an extended period of time. So reasonable compensation under this law must be payable under the legislative process.
Honourable Jenny Salisa.
I'd like to ask a question about section 137, which is about the consequences of record-keeping failures. And this clause seems to shift some of the practical burdens created by an employer's own record-keeping failures back on to the employer. However, this seems to depend on the authority exercising discretion. So I've got a couple of questions for the Minister. The first, can the Minister explain why Clause 137 gives the authority only a discretion to accept an employee's statement rather than a presumption in the employee's favour, where it is the employer who has failed to keep the record in the first place? And supplementary to that question, isn't it perverse that an employer who fails to keep the proposed records, the very failure that has caused, I believe, in the health sector, for example, millions of dollars to the taxpayer, why is it that at most the penalty seems to be about $10,000 or $20,000 penalty as any other technical breach?
Madam Chair.
Honourable Minister.
In relation to the Honourable Phil Twyford's contribution asking why the employer is given the ability to elect the remediation process, the process is intended to provide employers the option to address historical underpayments moving into the new law. Enabling employees to elect to use it could create complexity for employers where different employees may all opt for different approaches.
Honourable Giantinetti, I think we're pretty much on you indicated before you were pretty much at the end of this part.
Yeah,
so,
I'm not quite at the end of the part, but at the end of that, but I want to move on, but I'm not trying to prolong this, Madam
I
Chair.
recognise that.
Yeah.
I just think there's a good opportunity now just for you as the spokesperson to clarify anything left that you have on this part.
Yes, absolutely, Madam
Thank
Chair.
you.
And I really only have another couple. I know my colleague here has a couple about the transition to the new Act, but I wanted to talk about, in just a couple of questions, clauses 159 to 185A, which is the consequential amendments and the restructuring of parental leave. Actually, we think that the reported safeguards here are useful. However, employee entitlement must not depend on a private allocation dispute between old and new employers. Complexity from separate roles and hour categories will be amplified during the restructuring. So I've just got one question at this stage, and depending on the answer that comes from that, I may have a follow-up question. But the departmental disclosure statement notes that the transfer of personal leave information between employers in restructuring. And what I would like to ask is what advice was received on data minimisation, particularly family violence information? So that is something that we're quite keen to hear about. We had a bit of a discussion around this, that this could be a potential issue if that had not been thought about. So we do want to understand what the Minister was basing this on around that data minimisation, and as I say, particularly in that family violence area, being such a sensitive area that it is.
Honourable Minister.
Could I ask the member, is that in relation to any one specific clause?
It's relationship to all what comes through there in all of those particular clauses. We group them into 159 to 185A, and just really talking about that transfer of the personal leave information between employers in the restructuring process, which comes into there.
Right, yes. So the member is correct that, some information must need to be disclosed between an employer and a new employer if there has been a transfer within the ownership of the company to determine liability for costs of entitlements that would be recognised by a new employer. And I think everyone would recognise that that does need to happen in order to have a transition, and people can still get paid and still have their entitlements paid out. And it also helps to recognise some of the specified entitlements that an effective employee has accrued or may have become entitled to or not taken. it would be quite difficult, I think, on those grounds to then withhold information of entitlement to, you know, for example, family violence leave, given that it might be that people are in the process of going through family violence leave at the period of transition from an old employer to a new employer. So I personally don't share the concern that the member may have about, you know, the access to that information, given that access to that information is actually quite crucial in order to ensure that people are paid for that particular entitlement.
Honourable Phil Twyford.
Yeah, so this is my final contribution. So in relation to Schedule 1 and transition issues, I imagine there must be some sense of foreboding about rolling this out, given the complexity of it. The RIS says that a 24-month implementation period may not be enough for some employers. The departmental disclosure statement estimates that the education payroll may take up to 10 years. Education system being a graveyard for payroll systems, as we know. So I'm interested in what evidence the Minister relied on to set a 2-year transition for everyone else, and what other sectors may have been identified as high risk. In addition, I think it would be good for the House to hear from the Minister in relation to the transition, what implementation funding and milestones and programs are being put in place, and criteria for green light, red light, orange light through the implementation, given what's at stake.
Mm-hmm. Honourable Minister.
Thank you. Look, in regards to the timeframes of 24 months, I think where we've landed is quite sensible. Going from the top of my head, I recall very early on having conversations with people who were involved in payroll systems and the transition from an old law to a new law, and the technicalities that would be put in place by having that transition. And many of these people asked for 12 months. And out of an abundance of caution, I do recall at the time settling on 24 months to ensure that if there were any larger issues with payroll requiring even more time, or employers and employees needing more time, that at least having a 2-year period rather than a fixed 1-year period gave people a sense of comfort, because this is something that we do want to get right in those payroll systems as well as in the employment agreements. It also allows for time for renegotiation between employers and employees. I'm sure the member will be aware that during consultation the education sector did ask for an extended time frame, which I was happy to grant, because I'm sure everyone here is aware that the education sector historically has had issues with paying people correctly, and that was not something that we wished to happen under this law. So out of an abundance of caution that we could end up with remediation problems going well into the future based on transition that could go wrong, we've given them quite a long extended time frame. However, it is possible that they do actually do that before the extension of the time frame, rather than it being a backstop. In regards to a number of the other queries that have been raised, the Honourable Jenny Salasa queried clause 137 about why it gave the authority the ability to accept employees' claims rather than a presumption. And this clause essentially carries over the status quo under the current Holidays Act. It allows the authority to accept the employee's evidence as provided in the absence of evidence to the contrary. Tiana Tuiono also asked whether or not the Minister would commit to doing a regulatory impact statement on the remediation regulations. Officials will consider the requirements for any impact analysis as part of their work to develop the regulations and ensure compliance within those. And then the Honourable Jan Tinetti had also asked about What was the expected underpayment range that was modelled, or evidence that supported reasonable compensation rather than an entitlement, and consideration of the previous remediation payments under the Holidays Act will be part of the work required to design the regulations under clause 156 of the bill. The standard of reasonable compensation allows for a faster process. There is evidence to date that the current approach has taken a very, very long time for people to be paid.
Sue's Redmayne.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. The contrary, no. The ayes have it. Party vote is called, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumāori mana pōti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whanga pōti whakahe.
Taku Te Wheres.
Ko tahi te pōti whakahe.
Māori Manu Kapakingi.
Ko tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed. The question is that Part 3 stand part. All those in favour say aye. Aye. The contrary, no. The ayes have it. Party vote is called, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumāori mana pōti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whanga pōti whakahe.
Taku Te Wheres.
Ko tahi te pōti whakahe.
Māori Manu
Ko
Kapakingi.
tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed. The question is that Schedule 1 stand part. All those in favour say aye. Aye. Contrary, no. The ayes have it. Party vote call, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumāori mana pōti whakahe.
Act New Zealand.
11 in favour.
New Zealand
8 votes in
First.
favour.
Te Pāti Māori.
E whanga pōti whakahe.
Taku Te Wheres.
Ko tahi te pōti whakahe.
Māori Manu
Ko
Kapakingi.
tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed. The question is that Schedule 2 stand part. All those in favour say aye. Aye. Contrary, no. The ayes have it. Party vote call, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumāori mana pōti whakahe.
Act New Zealand.
11 in favour.
New Zealand
8 votes
First.
in favour.
Te Pāti Māori.
E whanga pōti whakahe.
Taku Te Wheres.
Ko tahi te pōti whakahe.
Māori Manu Kapakingi.
Ko tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed. The question is that Schedule 3 stand part. All those in favour say aye. Aye. Contrary, no. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumāori mana pōti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whanga pōti whakahe.
Taku Te Wheres.
Ko tahi te pōti whakahe.
Māori Manu Kapakingi.
Ko tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed. The question is that Schedule 4 stand part. All those in favour say aye. Aye. Contrary, no. The ayes have it. Party vote called, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakahe.
Act New Zealand.
11 in favour.
New Zealand
8
First.
votes in favour.
Te Pāti Māori.
I whā ngā pōti whakahe,
Taku Te Wheres.
ko tahi te pōti whakahe,
Māori Manu Kapakingi.
ko tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed. Members, we come now to our final debate on clauses 1 and 2, the debate on title and commencement. The question is that clause 1 stand part. The question is that clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for, please, Clerk.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakahe,
Act New Zealand.
11 in favour.
New
8
Zealand
votes in
First.
favour.
Te Pāti Māori.
I whā ngā pōti whakahe,
Taku Te Wheres.
ko tahi te pōti whakahe,
Māori Manu
ko tahi te
Kapakingi.
pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed to. The question is that Te Anō Tuiono's tabled amendment to clause 2, brackets 1, replacing second with third, be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for, Mr Clerk.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakae,
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
I whā ngā pōti whakae,
Taku Te Wheres.
ko tahi te pōti whakae,
Māori Manu Kapakingi.
ko tahi te pōti whakae.
The ayes are 55, the noes are 67. The question is not agreed to. The question is that Honourable Jan Tinetti's tabled amendment deleting clause 2, brackets 2, be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Mr Clerk.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakae,
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
I whā ngā pōti whakae,
Taku Te Wheres.
ko tahi te pōti whakae,
Māori Manu
ko
Kapakingi.
tahi te pōti whakae.
The ayes are 55, the noes are 67. The question is not agreed to. The question is that Te Anō Tuiono's tabled amendment to clause 2, brackets 2, brackets A, replacing the day after royal assent with 1 July 2027 be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. A party vote's called for, Mr Clerk.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakae,
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
I whā ngā pōti whakae,
Taku Te Wheres.
ko tahi te pōti whakae,
Māori Manu
ko
Kapakingi.
tahi te pōti whakae.
The ayes are 55, the noes are 67. The question is not agreed to. The question is that Te Anō Tuiono's tabled amendment to clause 2, brackets B, replacing 1 July 2027 with 1 July 2028 be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Mr Clerk.
New Zealand National.
48 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakae,
Act New Zealand.
11 opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori.
E whanga pōti whakai.
Tauku Te Wharis.
Whakai.
Māori menu kapakini.
Ko tahi te pōti whakai.
The ayes are 55, the noes are 67. The question is not agreed to. The question is that clause 2 stand part. All those in favour, please say aye. Aye. To the contrary, no. Aye. The noes have it. A party vote's called for, Mr Clark.
New Zealand National.
48 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārema ngā pōti whakahe.
At New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E whanga pōti whakahe.
Tauku Te
Ko
Wharis.
tahi te pōti whakahe.
Māori menu
Ko
kapakini.
tahi te pōti whakahe.
The ayes are 67, the noes are 55. The question is agreed to. Members, I will report this bill without amendment presently. Members, we come now to the Crimes Amendment Bill. We begin with the debate on Part 1, which is the debate on clauses 3 to 28, amendments to Crimes Act 1961. The question is that Part 1 stand part. Camilla Ballot.
Thank you, Madam Chair. At the start of this committee stage on the Crimes Amendment Bill, Madam Chair, just at the beginning of this committee stage, I think it might be worth just outlining the structure of this bill so members are aware the likely shape of the debate. So although this bill only has 2 parts, the Crimes Amendment Bill Part 1 is split into 6 different subparts, and each of those subparts has a different policy proposal which we are keen to ask the Minister about, and each of them are discrete and almost unrelated to the other parts of the subparts. So I know we will not be taking a vote on each subpart, but I'm just indicating to Madam Chair and any person sitting in the chair that we do have specific questions around each of these areas, and they are distinct from one another. And then, of course, in Part 2 we have the Summary Offences Act and other laws, but the Crimes Act provisions are distinct, and they are have been worked on and have a different legislative and policy history from each other, and so that's why I think it's important just to indicate that we will and we would like to be able to have the opportunity to question the Minister on those. So of course the first one that we're looking at is subpart 1, and this particular part is looking at the what would be probably colloquially known as the citizens' arrest provisions. The Minister may wish to speak to the history of this particular proposal. I do have the report of the Ministerial Advisory Group on retail crime with me in the House, and I understand this is something that they have advocated for in terms of clarifications and changes around that. But this particular right exists in the law already. There is already a right for citizens' arrest, and so that is the type of situation where you might have a security guard, most usually, or obviously it could be any other person. When they see someone committing a crime, they are able to execute a citizen's arrest, and that has been the case in New Zealand for a very significant period of time. So my question to the Minister is kind of an opening question in this particular part, is what advice did he receive and why was he convinced of the need to make these specific changes to citizens' arrest? And specifically, if we start with part 4, Madam Chair, you'll notice that the changes that have been made to the various subsections mirror each other, although they apply to different sections within the Crimes Act. A kind of more procedural question that I had for the Minister, if he wouldn't mind talking about the background of this particular section as well in relation to my previous question, is when I looked at the primary piece of legislation, I could see that there was an insertion of subsection 2 and 3 into part 35. But when I went back and I read part 35 of the Crimes Act, it appeared to me that perhaps there was a gap in the drafting, or perhaps another little numeral that needed to be included, because the provisions in clause 35, and I'm just looking at this now on my screen, do not have a number 1 in place. They have an A and a B. And so it might be that the Minister can receive advice that that's a minor and technical correction that can be made. I assume that when we're inserting 2 and 3, that we will have a subsequent and making of what remains in this provision, which is actually only the first sentence in 35A, made into subsection 1. But it would be good to get some clarity on that, but also some clear reasoning for the decision that the Minister made to insert these provisions as a policy decision.
Madam Chair.
Honourable Paul Goldsmith.
Thank you. And people tuning in to this, what we're dealing with is the Crimes Amendment Bill, which is the previous member talked about different elements. Yes, it does different elements, but it's all consistently, and I'm happy to answer questions on any elements of it in terms of responding part of the efforts of this government to restore law and order in this country. And there are different elements that this legislation addresses. We were concerned about the very high level of retail crime when we came into government 2.5 years ago, exemplified by ram raids and really a breakdown of law and order in the retail space, with too many examples of people not paying, leaving the place, shoplifting, just going out of supermarkets with trolleys full of food, and a limited ability to react. And so the citizens' arrest powers were one of the recommendations of the retail crime advisory group that we set up early on in this government, funded by the proceeds of crime. So it was the criminals that were paying for their efforts, so they worked, and one of the suggestions was the citizens' arrest power. As the previous speaker indicated, it already exists in law. Ultimately, this is about somebody hanging on to somebody until the police arrived, and currently you can do that after 9 o'clock at night, but for some reason you can't do it before 9 o'clock at night. So at 8:55 p.m, if you hang on to somebody, technically you might be head up for assault yourself, but after 9 p.m. You could. And it only applied to a certain number of offences before, and we're saying any offences against the Crimes Act. And so there was a change there in order to give an option to retailers, maybe security guards, to use. Another element was that the coward's punch legislation, been a widespread concern around the country of these, particularly cowardly attacks, where somebody attacks somebody with a punch to the back of the head or the neck, with no warning, with no indication of what's going to happen. There have been some significant cases that have been of great concern to people, so we wanted to send a stronger, clearer message and consequences for that, with aggravating factors and a specific crime. Now, I do want to acknowledge and thank the, in particular, Duncan Webb in terms of an amendment that we've agreed to around that, in terms of making it clear that if a jury was unable to convict for the coward's punch causing death, that they could, making it very clear that they could still convict on a general manslaughter if certain circumstances weren't passed. Then we're looking at the human trafficking and exploitation changes. We're very much against human trafficking and exploitation, and it strengthens our laws to align with international standards. These changes have been welcomed as long overdue, so that's an important element of it. Then the protection of first responders. These are the New Zealanders that rush towards danger on behalf of the rest of the community, and it's an unacceptable thing for them to be attacked, and that's why the bill strengthens protections for them, including police, ambulance personnel, firefighters and frontline corrections staff, that if you attack them in any way, there will be even tougher consequences for you, so that we send an unequivocal message on that matter. And so there are different elements to this legislation, but it's all part of that broader effort, Madam Chair, to create fix the basics in law and order and build a future where New Zealanders feel safe in their communities, and that we have a clear message around retail crime, around human trafficking, around coward punches, and there's another element to this in terms of the protection for undercover police officers that we can talk about as well.
The Honourable Dr Duncan Webb.
Oh, thank you, Madam Chair. Just sort of walking through the citizens' arrest provisions, just very interested in the Minister's views as to what happens, because this creates essentially a new obligation on police, because a person who does make such an arrest must, as soon as practicable, make contact with the police and follow the directions in relation to the arrested person. Now, there's a couple of things in there, and obviously if the police says let the person go, and you can imagine someone's stolen a bar of chocolate at a dairy, the police may well say, well, look, just let that person go, we'll deal with it later. One of the dangers here is that you've managed to subdue and restrain someone, and that's a thing I'll come to a bit later. That person's likely to be extremely agitated and may well deny that they've committed an offence and feel quite aggrieved. And how is the Minister going to address, if the police are not going to attend, how is the Minister going to address the safety issues that have arisen here? So that's my first question. If you've got to release this person who's going to be upset to say the least, particularly if they don't think that the arrest was justified. The second question is this, and many people in New Zealand sadly will know that the police don't always pick up the phone. We don't necessarily want the 111 line to be crammed, and in fact the 111 line doesn't go directly to the police. What happens if the police cannot be contacted? Now, for how long can a person be detained and restrained, so, you know, with cable ties or whatever the case may be? How long is a person expected to sit there whilst a shop owner is trying to get a response from the police, but they can't do it? Because there must come a point at which that detention becomes illegal because the police aren't responding. So, and again, that creates a safety issue as well, because if you've detained someone for an hour and a half and haven't managed to get the police, you think, well, I better let them go. Again, we're getting back to square one in terms of that safety issue. So there's two questions. How do we address the safety issue when the police say, oh, we can't make it, let them go? And what happens if, despite best efforts, you can't get hold of the police?
The Honourable Paul Goldsmith.
In relation to the first question raised by the member, of course, it is not compulsory to perform a citizen's arrest on anybody at any given circumstance, so the individual who's doing that will have to make a judgment about whether they think it's safe to do this in the circumstances. And there's been a lot of concern raised by some people that this is dangerous. Well, we have every confidence in New Zealanders to be able to make that judgment for themselves. And if they do think it's too dangerous to do this, they won't do it. If they think that they can safely hang on to this particular person, then they can. We give them the tools to be able to do that. So, in terms of safety, it will come down to the calculation made by the person who is deciding whether or not to perform the citizen's arrest. In terms of the police arriving, not being able to get hold of the police. Well, the clear part of the legislation is that you are obliged to get hold of the police as soon as practicable. I'm not aware of instances where it takes 2 days to get hold of the police or any extended period like that. There may be a delay, but we have every confidence that people will be able to get through to the police at some point in a timely fashion, and then we need to follow the instructions of the police. And if that instruction is we don't have the capability to attend this in a timely fashion, therefore you should release them, then that's the instructions and they should be followed. This legislation doesn't solve or doesn't change the need for police to prioritise their response as they do now.
Dan Rosewarne.
Thank you, Madam Chair, and thank you to the Minister for those questions. And I just want to talk to the Clause 4, which expands the citizens' arrest provisions in the same line as what the Honourable Dr Duncan Webb just did. The concern is whether this clause strikes the right balance between empowering victims of crime and ensuring public safety. And that's why I'm interested in how the government expects these powers to actually operate in practice, and what guidance will be available for people who choose to exercise them. And then just scanning back through some of the submissions, Minister, this is one from the New Zealand Council of Trade Unions, and I'll just paraphrase some of their statements here. They highlight that the proposed changes to citizens' arrest and defence of property provisions are of particular concern and represent a misguided approach to retail crime, which will compromise worker safety and employment rights. And they also go on to say that expanding citizens' arrest powers and defence of property provisions with the intent that they may be used more frequently to protect business property, explicitly exacerbates workplace risk. So I suppose my questions there, Minister, is what guidance or public education does the Minister expect will be provided to retailers and members of the public so they actually understand the limits of these expanded citizens' arrest powers? And the second question is, has the Minister received advice on how often police may be required to respond to citizens' arrests under the expanded regime, and what operational impact that could potentially have on frontline policing? Thank you.
Madam Chair.
The Honourable Paul Goldsmith.
Look, in terms of risks and danger to workers, of course, the far bigger risk to workers has been that they will be victims of crime. And there were a lot more of them under the previous administration that member represents, where every day we were hearing stories of ram raids, people who live upstairs in a little dairy and woken at 3 o'clock in the morning by somebody smashing into the ground floor and putting their lives at risk, we have endless example of retail crime. And so the biggest thing we can do to improve the safety of workers in the retail space is to reduce the number of victims of crime and restore law and order, which is what the broader program of what government has been focused on. In terms of this particular change around citizens' arrest, I again put back to you, the current law allows this to happen after 9 p.m. at night, and I don't hear anybody saying that we should repeal that law or that somehow it's inappropriate. What I'm saying is that it seems a very strange logic that these laws, these powers should be available at 9 p.m. but not available at 8:55 p.m. Or 7 p.m. or 3 p.m. Because it's the same situation that we're facing. And so I think what we're doing is a perfectly rational thing. Yes, we have extended the number of crimes. Before there was a limit around the seriousness of the crime, and we've extended that scope. But we have every confidence in the ability of New Zealanders to be able to assess the situation and either act or not act, depending on their assessment of that safety.
Honourable Dr Duncan Webb.
Well, thank you, Madam Chair. Still, this is you can't really underestimate how important this is, because we are expanding the rights of citizens to infringe the liberty of another citizen. So we're essentially subcontracting the power of the state down to citizens who use their own judgment as to when this occurs. So I just want to emphasise that this is a really important point. And I'd point out that the Justice Committee recently looked at some Corrections Act amendments in terms of what corrections officers, what preconditions had to exist before corrections officers could do things like use physical or mechanical restraints. And here, there's no such constraint. So, for example, it appears that a big adult could use physical or mechanical restraints, handcuffs, or even chaining tying up the feet or whatever on a young person. And so I'm interested to understand if when a person detains, because it doesn't seem that this excludes children. In fact, they just have to have been likely to have committed reasonable cause to suspect they've committed an offence against the Crimes Act. So what force can be used and what restraints can be imposed? And then this is really concerning, because the 8:55, 9 o'clock distinction might be one that the Minister's got a point on, but if we look at the use of force, the Minister has gone through and deleted throughout the Act the limitation on the use of force. Now, force can be used to restrain, but under the current law, you can't strike someone or do bodily harm to that person. But those provisions are now deleted. So it appears that a person who's making a citizen's arrest can in fact bash the person who has committed the crime. Now, the police can't do that. They can restrain someone and use reasonable force, and they certainly can't do bodily harm. So, Minister, why have you removed the provisions which stop a person making a citizen's arrest from causing bodily harm to the person who is suspected of committing a crime? And why have you removed the provision which stops them hitting the person who is suspected of committing a crime?
Madam Chair.
Camilla Ballard.
Chair.
Thank you, Madam Chair. And just reminding the Minister, I haven't yet heard a response in relation to the kind of drafting issue I raised in my first contribution. The question that Dr Duncan Webb raises around children is something that did come up in submissions, and I know that at various points in time the Children's Commissioner has been consulted on this bill. And so a question for the Minister is, do these changes allow children of any age to be detained under a citizen's arrest? And the reason that that's important, because we've heard the Minister say that these exist, and we've heard his colleagues say that from their side of the House as well, is exactly the point that Dr Duncan Webb was making, is that protections in relation to citizens' arrest have been removed in Clause 8 and in Clause 10 and in Clause 11 and 12 of this bill. And I wanted to ask the Minister, in terms of the situation prior to these changes, so the current status quo, what evidence does he have that there was a need to remove the prohibition on grievous bodily harm in these types of citizens' arrest situations? Can he point to an example of a case of where there was an unjust, in his view, or a prosecution that appeared to be unfair due to the force that was used during a citizen's arrest? And we have to, I do want to draw the House's attention to the example that is put in place. We did see, and we've seen in the RIS through some consultation that has taken place, the objection to the use of inserting the use of physical or mechanical restraints. Tying someone up is a probably colloquial way of referring to that. And that is, there are people that have raised concerns around this in terms of the impact and the type of justice system that we are looking to implement in New Zealand, where we are allowing, or in fact encouraging through legislative change, a change to the availability of a citizen's arrest to allow those kind of, I just wonder if the clock is, we can just, sorry. Thank you. I do have some specific questions as well, which I would like to ask before we move on to a different part of the bill, or before we move on to a different clause. I don't think we've had an answer to what the exact process would be that the Minister imagines when a citizen arrest occurs. He said that it's likely to be timely, and he can't imagine it would take a constable a very long time to get there. But what about the situations where this has happened in a remote location, or it is a rural situation? How long does the Minister envisage that restraint? And we've seen that includes perhaps tying someone up, and we've asked the question, does that include a child? How long can that reasonably be considered to occur before that becomes something? And there is I think at least a common law principle on unjust imprisonment, and I wondered, did the Minister receive any advice on the interaction between that common law right to not be unjustly detained and these citizens' arrest provisions? Additionally, during the Select Committee process, we did hear concerns from retailers around the responsibilities that they were expected to engage with in that. And so I wanted to know, does he have a response for retailers who are concerned that their staff will be put in a situation where they are expected to detain people more readily? And is that his expectation from this bill, that would be a process that they would go through? I also have a technical question around the deletion in, we have in clause 4 the deletion of the term certain crimes, and then in 6 we have certain crimes maintained, and I wanted to know what was the reason for that discrepancy within the bill in terms of terminology. Why is it kept in one part and why is it deleted in another part? And so I think, Madam Chair, I didn't realise the clock wasn't on, so I won't use all of this call, but I do think there are some outstanding questions in relation to those technical elements, and also the use of particularly the interaction of the existence of the defence of self-defence and the fact that the Minister has inserted clauses which make it easier, or in fact possibly encourage the use of physical and mechanical restraints, and the defence of striking or bodily harm against a trespasser. So I would be grateful if the Minister could address those questions.
Madam Chair.
The Honourable Paul Gosman.
In terms of whether it applies to children, the answer is yes, and we wouldn't want a regime that encouraged particularly organised crime to use children just to get around any potential response. But the point that I make, which relates to all the questions that have been raised, is that the obligation is on the person who's performing this to immediately contact the police as soon as practicable and follow their instructions. If the police, if it was in a very remote place, then the instructions may be different to whether if they're have the capability of arriving in a timely fashion. So we've got every confidence that the police will be able to deliver reasonable instructions. In terms of defence of property, it is still required that any force needs to be reasonable force. So bashing somebody does not fall generally within the realms of reasonable force, as I'm sure the member knows. In terms of requirements for employees, it is a perfectly legitimate response for a large retail entity to have a company policy that they won't use this. That's perfectly possible. So that may be a solution that a particular retail entity wants to adopt, and they can explain to their customers why that's their approach. It may be that a huge part of our retail sector is small self-employed businesses, and they may have a different approach. And so we've got a wide variety of people within the retail sector, and so this is about providing an option and a tool, but it is not compulsory in any way, shape or form.
Ingrid Leary.
Chair, I've been listening very carefully to the debate, and the questions raised by my colleagues and the answers from the Minister show the loose logic about causation and also response. And the Minister himself has blown the debate wide open, in my view, when he talked about ram raids and made the same very loose assertion that actions taken by this government, legislative actions, have reduced ram raids. And so I want to ask the Minister, and this is referring to clause 4, because that was where he made those comments, what evidence he has that his government has reduced ram raids. For example, has he taken into account the ageing of the youth offender cohort who were responsible for them? What impact did the actions of the previous government have in terms of reducing ram raids, including fog cannons, bollards and so on? What about the court responses, and what evidence does he have? And I will say there is no evidence that there was a causal nexus, because what evidence does he have that the laws were implemented when the ram raid numbers were coming down? In fact, the ram raid numbers were coming down when his government sentencing changes and so on came into effect. And the reason I raise this, Madam Chair, is two reasons. One is the Minister himself made that assertion that ram raids were coming down as a result of their legislative changes and their changes, so I'd like to see the evidence for that. There isn't any. And secondly, to show this House and viewers that the kind of logic that the Minister is using is completely inappropriate and is fundamentally changing the jurisprudence of our country, where now police have one set of rules, citizens had a set of rules, they're all conflated, and retailers are suddenly expected to be agents of the state. Again, Madam Chair, this was raised by the Minister himself, and so I'd like the Minister to please respond to those issues that he brought into the debate.
Well, Madam Chair, I can.
Paul
The member is entirely wrong in her assertion that retailers have been turned into agents of the state. None of this legislation is compulsory for anybody. Nobody has to do anything under this legislation in regards to citizens' arrests. It is purely something that people may choose to use if they want to. If they don't want to, they don't have to. They can just stand back and let people walk out of their shop stealing whatever they like. If they want to, that's their choice. And in terms of reference to ram raids, I was just referring to that. It is not related to this legislation. I was just giving some context to this government's efforts to restore law and order. And I leave that to the people of New Zealand to judge as to whether things have improved over the last 2.5 years. And there is a whole range of factors behind that that I can point to, but I won't prolong the debate further on that.
Before we move on, I think we've gotten stuck on this bit, so please expand some of the questioning for the Minister, Honourable Dr Duncan Webb.
And I know that my colleague Camilla Bellich wants surely to move to the slavery and trafficking provisions, but there's just one question, and I'll keep it brief, on this arrest in defence of property, citizens' arrest situation, and that is the liability of the arresting person, the citizen, because if you look at each of these provisions, the subsection 3 identifies that the person will be liable, and that could be civilly or criminally, if they don't follow the directions of the police. But there's a carve-out in there. So it says a person who, without reasonable excuse, breaches subsection 2. So you call the police and the police say, let that person go. And I'm just curious if the Minister can explain to me what would be a reasonable excuse for not following the directions of the police. And if he could, whilst he does that, just clarify, because I think it's actually really important to put on the record, that if the police say, release that person, and they unreasonably don't, then they themselves could be liable for crimes of, I don't know, false imprisonment, presumably assault, both of which would be serious. Well, arguably kidnapping is the appropriate crime because you're detaining someone illegally against their will. So I think it's important that the Minister identify that a person who detains someone and doesn't follow the directions of the police without reasonable excuse could in fact be liable for a crime many times more serious than shoplifting or any other offence that might have been committed. And also, when will it be reasonable not to follow the directions of the police?
The Honourable Minister.
I think the threshold of without reasonable excuse is one that the courts are very familiar with and understand. So that's a matter there. A speculation might be that the arrested person was threatening violence, perhaps, but that's something that courts consider on a regular basis. In terms of liability for not following instructions, that is clear, that there is civil and potentially civil or criminal liability remains if anything happened outside the law, whether it's an unjustified arrest or subsequent injuries or use of excessive force.
Camilla Bellich.
Thank you, Mr Chair, and just kind of a final thing on that subpart. Is the Minister going to be undertaking some education around the appropriate use of these changed powers? And also, is the Minister intending to review the use of these powers if, in fact, there are some of the concerns that the submitters raised in Select Committee do bear out in terms of the utilisation of these slightly altered powers? It would be good, I think, to know whether that was his intention on both those counts. I would like now to move on to the second subpart, if I might, which is a part of the bill that the Labour Party supports and agrees with, which is the changes in relation to human trafficking. And I just wanted to acknowledge that this whole bill is a collection of quite a few different things. So in here we have a members bill, we've also got various coalition agreements put in place here, and we've got recommendations from the Ministerial Advisory Group on Retail Crime. I'm not sure if it's worked entirely, putting all of these different parts together in terms of especially some other sections of this bill, but this particular part I think is one that is worthwhile, and I personally support it, and also the Labour Party supports it. I think it's been something that's been called on for a long time, and I know that it came as part of a members bill that I think was originally, possibly, I might be incorrect in this, it might have been in Nicola Grigg's name, and then it was in Greg Fleming's name, and it was pulled from the ballot, and I think it had its first reading, but it is now part of this crimes amendment bill. And it does do some important work that links up to the work that the Parliament is doing on modern slavery in terms of definitions, and in terms of making sure that there is the appropriate modernisation and alignment in terms of something that all New Zealanders would disagree with, which is any form of slavery or exploitation, and we're talking around the very serious end of these with these particular provisions as well. So I just wanted to acknowledge that to start with the history of this particular subpart. And I do have some specific questions in relation to this, although probably likely to spend less time on this particular subpart compared to the other subparts, because there's, I do believe, widespread agreement that these are good, positive changes for New Zealand to implement. Questions I had for the Minister are quite specific, so I hope he can hear these questions. I wanted to know whether he, in terms of the definition of exploitation, considered putting in child labour or slavery, servitude, sexual exploitation or harbouring, which I know were, I think, some aspects of that were part of the original bill and were removed at Select Committee. I want to know whether he was minded to include those definitions in an amendment that could be brought to this House. The other thing that I wanted to ask him specifically was the change in relation to the definition of the act of coercion. That's in clause 15, and it changes 98B of the primary legislation. This is a change from the change to against a person, and I just wanted to know the reasoning why the change in relation to a person was chosen, if he could get some official advice on that. The next question I had is in relation to clause 15.3. In this definition of unauthorised migrant, there's reference to a state, and when I was reading through this, I wasn't clear, and maybe that's a deficiency in my analysis, but I wasn't clear whether the state that is defined an unauthorised migrant will always be New Zealand, or whether this is in fact a reference to any state, because obviously this is a particular provision which does have some international elements to it, unfortunately, where we have less control over the rights that people have, but I just wasn't clear on that, so I would be grateful to know the answer to that question. I think that's all the time I have for that, but there may be some other questions.
Honourable Paul Goldsmith.
Mr Chair, just in answer to some of the questions raised, she asked about whether we'd be issuing guidance around citizens' arrest. Yes, the police will be issuing guidance. In terms of reviewing it, frankly, legislation is always under review. There's not a specific time set aside, but yes. In terms of and I thank the member for her support of the the human trafficking and smuggling element of this legislation. I think there has been widespread support across the House for this to be done, and I'm pleased that we've been able to progress that. In terms of the question was raised around whether child labour was specifically referred to in my advice, is that is already captured by the broader definitions in the legislation. In terms of definition of an unauthorised migrant, the state applies to any country, not just to New Zealand. It was a question that was raised. Obviously the goal of this part of the legislation is to keep to strengthen our trafficking and smuggling and exploitation offences and make them more workable. I mean, and I'll just draw attention to particularly to removing the need to prove coercion or deception where the victim is a child, and it increases penalties for slavery and child exploitation, and clarifies that a victim cannot consent to being trafficked.
Dr. Lawrence Junan.
Thank you, Mr. Chair. I just want to check one, quick thing, just in case it hasn't been addressed, but Minister, feel free to just nod if it has been addressed, which is around clauses 8 and 9. I just want to check with the Minister. I agree with the Minister. I'm grateful that the Minister mentioned that there will be guidelines issued by the police, but I just want to check, when we're looking at citizens' arrest, particularly section 39 and 40, when it comes to mechanical restraints, what sort of safeguards will be placed there for people to not arbitrarily, unnecessarily place medical restraint on children? Because as we know that there are no age requirements with some of the changes that we see in clause 4. I am going to move on to subpart 2, Mr. Chair, on slave dealing and human trafficking offences. And I do want to just follow up on the previous speaker, Camilla Ballich's question around the definition for unauthorised migrants in clause 15, subclause 3. And I particularly want to focus on B of that and just ask the question to the Minister on how then would one, either through immigration or through other means, determine or uncover if a document was obtained by deception, fraud, forgery, other unlawful means, noting that some of the forgery that we do see could be in other jurisdictions that's not, that can be quite sophisticated, but also in jurisdictions where by translation or methods of obtaining documents could not be how we here in Aotearoa, New Zealand, see the standard process of obtaining those documents. So I guess one half of the question is how do we uncover if there are fraudulent or forgeries? And number 2 is what are the checks and balances that we have to not have unfounded bias towards certain countries on their system to obtain official documents? Those are my questions for the time being.
Camilla Ballich.
Thank you, Mr. Chair. And I do just have a few more genuine kind of questions in relation to the workability of the trafficking changes, which, as I've said, we support, and we're hopeful that these will be a really positive change in relation to the way that we address trafficking in New Zealand. So the question I have is, one of the major changes in relation to these particular amendments is around the need for the Attorney General's consent for prosecutions. And I think it might be worthwhile if the Minister could just explain that change, because it appears to me that this is, as I've said, we're supportive of that, but it is something which will still apply in relation to offences that occur outside of New Zealand, if my understanding of that is correct. And so if you could maybe explain that, that would be really helpful. In terms of, I had a specific question in terms of clause 17 too. I looked at the original legislation, and 17.2 repeals 98E3, and that is a generality paragraph. So it just was an interesting thing to me to see that, and I'll see if I can bring it up quickly if I have time. But I think I was confused as to why it was suggested to be deleted when it appeared to give a bit more flexibility to, sorry, I don't actually have it right in front of me, so I don't want to spend too long looking for it. But anyway, when I did read it previously prior to this committee stage, I had a question around why that was deleted, and if I can bring it up again, I will. So these are the questions that I have. The final one that I'll raise is in relation to trafficking. I did have an overall question, which is, does the Minister have any information about how prevalent these trafficking offences, and I'm sure they're abhorrent to almost anyone who reads that this is something that, that may in fact occur, if he has any information on that occurring. And then just a related question to my colleague Lawrence Zunan in 98, that's new clause 16, but it's a change to 98.4, and the change in relation to understanding, or they believed on reasonable grounds, that a trafficked child was over 18. And I just wondered what those reasonable grounds might be, because that seems a little bit at odds in terms of the usual presumption that we would say that if you're looking at trying to determine an age of a child in relation to an offence, there would be a duty to be able to assure yourself that someone is of a certain age, rather than the opposite, that you might think maybe they, on reasonable grounds, are a bit younger. So that kind of stood out to me in terms of that section. But as I said, generally very supportive, and so asking these questions from a workability perspective, and wondering if the Minister could just enlighten us to ensure that those are the best possible changes.
Honourable Minister.
Just running through some of those questions. In terms of removing the requirement for the Attorney General consent, it just removes an unnecessary barrier to prosecution, speeds up trafficking prosecution, and brings it into line with other serious transnational offences. In terms of Mr. Shunan's question around how do we determine whether documents are fraudulently obtained or brought through immigration, the immigration has a department responsible for determining the legitimacy of documents. They're experts in that. It's not just it is an area of expertise that they have. It ensures that individuals who have fraudulently obtained documents will be captured. In terms of the data of the scale of the problem, that is by its nature rather hard to get, because this is a secretive business, and so we've had indications that we've missed the ability to deal with examples in the past, and that's why we're changing this law. But the overall scale of it, in the context of New Zealand, we don't have a good handle on, but we will be in a better position to get a better handle on when this legislation is passed and more tools available to respond to it. And in terms of the sort of reasonable belief in terms of the age, other offences in the Crimes Act, such as sexual contact with a younger person, both require reasonable belief and reasonable steps taken to find out somebody's age. And so for the child trafficking offence, if the offender reasonably believed the victim to be over the age of 18, the general trafficking offence remains available. The general trafficking offence remains available as a charging option.
Mr. Chair.
Honourable Dr. Duncan Webb.
Thank you, Mr. Chair. I just have one question, and it is around exploitation and the definition of it. And this is clause 15. My concern is essentially that the way we look at slavery, forced labour and exploitation kind of is a little old-fashioned in that it looks for threats of physical harm or physical restraint. And if we look, for example, at the definition of forced or exploitative labour, it's identifies it as being extracted from the person under the threat of or by causing harm. So, whereas what we actually see is people being seduced, if you like, into a relationship that is a coercive relationship, but often without any physical harm being threatened. So if we take, for example, Gloria Vale, which has a long history of very problematic relationships of servitude, there may well be no threats of physical harm or restraint, but the relationship is one of such coercion and control that there is, in real terms, no ability of the people there, and in other cults as well, there's no ability of people there to refuse the demands of their superiors. And what we have then is forced or exploitative labour, even though they're not physically restrained. There's no suggestion that they'll be physically punished if they don't follow orders, but because of years of essentially reinforced training and feedback, they are compelled, and the demands put on them, along with the absence of any remuneration and the hours of work and so on and so forth, add up to something which, at least in my view, should be recognised by the law as forced or exploitative labour. Now, taking the argument outside of that concrete example, is the Minister of the view that this framework around exploitation will be met in cases of non-physical coercion and control, and if not, is any work being done in that space?
Mr. Chair.
Honourable Minister.
The definition of exploitation, it's a fair point that the member raises, has been written to align with the Palermo Protocol. It doesn't require there to be threats of physical harms. Courts have interpreted harm to include psychological harm, and threats of harm to others included in the definition of harm. So that's a response there.
Mr. Chair.
Kamala Bellich.
Thank you, Mr. Chair. I wondered, I appreciate colleagues may still have some questions around the trafficking, but I did want to ask around the linked provisions of undercover protection officers, which is in subpart 3. In relation to the link to subpart 2 is, I think not in itself objectionable, but I do have some questions around the way in which this will be implemented, because it does appear to be quite extensive protection for undercover officers, and appreciate, especially in this exploitation space, undercover officers do some very difficult work and disturbing work, and certainly in New Zealand there has been, in relation to child exploitation, a certain amount of ability to prevent exploitation from occurring, not only with the police but also through internal affairs. So I think that is important to recognise the prevention element of this. But I am interested to know from the Minister, especially in relation to the clause 18.7c, this provides a certificate to be signed by the Commissioner of Police that someone was acting as an undercover police officer, and quite strongly worded that it is conclusive evidence of the fact that they're acting as an undercover police officer. Now, I know that most, if not all, commissioners of police will be able to act in a prudent, responsible way in terms of these certificates, but we have had some issues in New Zealand in the past where some of the actions of undercover police officers have been questioned as to whether the extent of their deception was necessary in relation to the task that they were to provide. And we've had examples of people having relationships with people who were unaware of their identity and families, and there's been issues in the past that have been raised as to the extent to which an undercover police officer should act in this way. And I don't know enough about any of the details of those cases that I've referred to know whether to make a judgment here about the appropriateness of that. But it seems to me that a statement around the conclusive evidence of the fact that they were at a particular time acting as an undercover police officer, and as a result of that, essentially there being no, my reading of this, no particular way that any of their actions could be scrutinised does appear to be significant. And so just specifically again in a situation, we're not talking about documents now, but if we talk about someone who was acting in bad faith, or sought to utilise these provisions without good faith, I think it would be worth the Minister just stepping the House through how he sees these particular provisions working to enhance safety and as a protection against any bad faith actor in the future. And of course we're assuming that that won't be the case, but when we're legislating we need to make sure that it's robust enough to ensure that no inadvertent loopholes are found where bad faith actors are permitted to conduct that activity without scrutiny.
Honourable Minister.
I can sort of assure the House that the protections in this subpart that relates to undercover officers draws on or aligns with the protections for those available for undercover officers investigating drug or firearms offences, and it's standard practice for protections of this kind. The certificate is part of that. So, I mean, we could have a broader discussion around that whole process, but that this bill is not sort of adopting a new system. It is aligning it with the current approach that is taken in other areas of the law.
Mr. Chair.
Governor Bellich.
I understand my colleague does have a genuine question, not a closure motion.
Yeah, no, that's right. We're still on.
Yep.
We're moving to that part shortly.
Yep.
Very shortly.
Thank you, and thanks to the Minister for that. Mr. Chair, we are now, I think, probably at quite a significant part of the bill, which is in relation to subpart 4, which is what is known as the coward punch provisions. And I have to say, if you, Mr. Chair, were heartened by the bipartisan cross-party support for the previous provisions, unfortunately the exact opposite is occurring in relation to this particular subpart. And I think it's worth noting that this is a government bill and we have amendments on the table. We have we have amendments from the Minister, we have amendments from New Zealand First, which is a government party, and we have amendments from the ACT party in place. And we also, and the Minister talked about this earlier, have the government has accepted some assistance from my extremely intelligent and good at drafting legislation friend, the Honourable Dr. Duncan Webb, in terms of these provisions. So in terms of, and this is not at all a reflection on the people working on this bill, but this is a bit of a mess. And I think it is incumbent on the Minister to explain to the House how we have ended up in a situation where, and I've looked back through the original RIS, and the Minister has been battling not only with his coalition partners, but also with the Ministry on this particular provision. There has been constant battles in the way that this particular provision comes to the House. And this is very serious because these coward punch provisions, and we should all keep this in mind in our debate on this, we've had families in New Zealand who have been devastated through the loss of their loved ones through violent attacks, and we must keep that in mind. The motivation for trying to change some of these laws to alleviate some of the suffering that those people, not only the victims of those types of attacks, but because we have a grievous bodily harm provision in here, the survivors of those attacks, and to give comfort to their families is something that I don't think anyone in this House would disagree with. But these provisions go further than just the families that have unfortunately had to suffer through these attacks, and they do apply and potentially have an impact on whether prosecutions on coward punch type offences will actually be successful in obtaining a conviction. So there's quite a few elements to this, and I imagine that this will be a larger part of the committee stage debate because of all the views that we do have on it. It is important to note that when we went through the select committee process, the clear advice that was received from the Ministry of Justice was that these provisions should not go ahead. And the amendments from New Zealand First and the amendments from the ACT Party, and in fact the Select Committee's own involvement in this is to try and find a way forward where there can be a fair law that works for New Zealand despite these various views on how this coward punch provisions in relation to manslaughter, in relation to grievous bodily harm will be put in place. So, Mr Chair, this is a significant provision and a significant change to our law, and one of political significance, and one that does not reflect well from an opposition perspective on the unity of the government or to be fair, the leadership of the Minister in relation to this provision. So he has the opportunity to respond to that. I'm sure that he will want to do that, but we do have several contributions, and I think other parties will also want to make contributions because this is such a contentious, such a fraught and such a difficult part of this bill that I imagine will be amended in the future. So if the Minister wouldn't mind responding.
Mr Chair.
Todd Stevenson.
Thank you, Mr Chair. First I want to start off with, I am going to ask the Minister some questions around Clause 19 of the Amendment Bill, but I do want to acknowledge that, the government is still united, the government parties are still united on dealing with law and order, and I want to acknowledge the Minister's leadership on actually dealing with getting victimisation of crime down over this term. Why ACT has put up an amendment in relation to what's called the so-called coward punch is pretty simple, because we want to make this fence actually useful. And Camilla Bellich is right. We heard lots of testimony at the Select Committee about how these heinous acts, and again, a coward punch is basically when someone is attacked out of the blue, almost inevitably without any kind of provocation, and they have no chance to defend themselves. And the outcome is death. And that is a very, very serious crime. And also what we heard, Minister, and again, I'd be very keen to get your reflections on this, but what we heard is in sentencing around, and at the moment it would be a sentence of manslaughter, but obviously the circumstances are that of a coward punch, we were seeing people receiving just an average sentence or 3 or 4 years. Some even getting home detention. And so what my amendment does, and again I want to thank the Select Committee because we did discuss this at length, but what my amendment does is actually says, well, if this new offence is going to be charged, and we'll just call it the coward punch offence, it's slightly more complicated than that, but let's just call it that for this questioning. If that offence is going to be charged, there needs to be a consequence with that. And so what my amendment does is, if that offence is proved, then there is a minimum term of imprisonment of 8 years. And so what we're trying to do is say, yes, we're happy to support the creation of a new offence. It's got some new elements that have to be made out, that does actually require, again, as Camilla Belch said, does require the Crown to prove different things. But if they are able to do that, then there should actually be a sentencing consequence for that. Now, yes, obviously the Crimes Amendment Bill only deals with the Crimes Act. Unlike, again, and again, ACT has got some experience in this. We obviously got 3 strikes reinstated, and again, I want to thank the ministers for his support on that. But we knew what we were doing there. We made sure that the right different pieces of legislation were amended. Because obviously this bill only deals with the Crimes Act, my amendment on behalf of ACT has been very carefully drafted to ensure that the outcome I've just described can be achieved, but it's done within the scope and the nature of the Crimes Act. And so I would be keen to get the Minister's perspective on this, because I know he is also concerned about sentencing outcomes and making sure that the community actually, because that's what New Zealanders want. They want to see consequences for serious crime. And again, as I said, with the 3 strikes regime, we've now got serious serious physical and sexual violence is now dealt with in a regime. But I do think there is still a community call to make sure that other serious offences actually get imprisonment as the outcome and not just home detention. So thank you, Minister. I'd be interested in your reflections on my amendment.
Casey Costello, Honourable Casey Costello.
Mr Chair, thank you, and I recognise the member that has just taken a seat in regards to providing an assurance that the government is united, the government parties are united in terms of the seriousness of the coward punch. So I would like to talk just specifically to the amendment in my name, number 650, relating to subpart 4, to coin the phrase, the coward punch provisions. Again, similarly to the ACT Party, New Zealand First has been very keen to ensure that this piece of legislation is workable, but New Zealand First has advocated for many years to ensure that coward punch is recognised and differentiated because of the unique and particularly brutal nature of the coward punch law. And for those that are watching at home, we're not talking about a stray punch in a fight. We are talking about a system where someone is attacked in a way that they are not only able to defend themselves, but not even able to prepare for the fall or the impact of that assault. So that we are talking about a very unique type of offence, and therefore recognising it in law and acknowledging the very hard work that Justice Select Committee has done to address the anomalies in this piece of legislation. This is about sending a very clear message that we as a society find this intolerable, and this is why New Zealand First has fought so long and so hard with various private members' bills over years to get this to the House, and I will acknowledge our previous MP Derek Ball for his hard work in this space. What we're trying to achieve here is an assurance that upon conviction there is a differentiation, and I acknowledge the work that has been done to make sure that that we will still have a manslaughter conviction if the ingredients of cow punch isn't achieved. But we also are seeking a minimum term of imprisonment of 8 years, and this is to ensure that upon conviction we are taking seriously the nature of this assault. And we all recognise that manslaughter occurs in varying degrees around the circumstances that gave rise to someone losing their life. But when the intention is formed for a coward punch, we are setting into a very different realm. We're not just talking about the fact that I was in a fight and things went awry. We're talking about someone who formed an intention to attack someone in a method that has a high likelihood of causing serious harm, if not death. So this is the amendment that we have put forward, is recognising this will require some amendment to the Sentencing Act, is to ensure that there is a very clear message that there is a minimum term of imprisonment applied, and this is about ensuring there is a differentiation, that there is a real recognition of the level of harm that will be caused here. And yes, it is a complex piece of legislation and it has been difficult to reach this point. And I do, I'm fully aware of how much work has gone in through the Select Committee process to achieve this workable legislation in the end. But I think we are united in the seriousness in which we consider this type of assault. And I think that the amendment that we've put forward is to ensure that there is a seriousness attached to a conviction in this space, and that once the ingredients of this offence have been proven and a conviction is applied, that should equate to a term of imprisonment. And it is not without precedent that we have minimum mandatory sentencing. It is, I know, a subject that is challenging, but I think it is important that we recognise the enormous level of harm and loss that this, and sending a clear message that this type of assault, this type of attack on an individual, when there's such high likelihood of the level of harm that is caused, should be differentiated in the manslaughter space, and therefore I'd sort of ask the Minister to give that his consideration in the amendment process.
Honourable Paul Goldsmith.
Mr Chair, thank you. I just want to acknowledge the two previous contributions from government parties in relation to the Cowards Punch Act, and I think they've traversed well the real public concern that there has been around this particularly heinous crime and the cowardly nature of it. And so what we have in this legislation is a tougher consequence in terms of the maximum penalty for a coward's punch leading to with grievous bodily harm, so not causing death but grievous bodily harm of 15 years, and causing injury of 8 years. And then we brought in a specific offence in relation to a coward's punch leading to death. Already, of course, the manslaughter provision is significant already, but we felt on balance that it was necessary to, in the legislation, have a particular offence relating to this to make it very clear to the public that the Parliament of New Zealand denounces this particular act, and there are specific consequences for it. Now, there's a lot of debate around how best to achieve that, and because the manslaughter offence, we wouldn't want a situation where the higher hurdle of proving a coward's punch wasn't met and somebody got off scot-free, and so I do acknowledge the legislative proposal from Duncan Webb to make it clear that a jury could also consider a general manslaughter charge. The advice was that would be the case, but it doesn't hurt to make it clear in the legislation. Now, when it comes to the question of mandatory minimum sentences, that there is a disagreement between the government parties on that matter, and I'll just explain our logic from the National Party point of view, which is to say we've done a lot over the last 2.5 years to restore real consequences for crime, such as bringing back 3 strikes, and in particular putting a cap on the amount of discounts that judges can apply, capping that at 40%, and I think people were rightly concerned when discounts were going into the 60s and 70s percentage, and people were being convicted of serious violent offending and ending up on home detention. So we've made that very significant change. Allied to that was stopping funding cultural reports, which is, some people might think it's a minor thing, but it actually is an important signal that we don't agree with the sort of culture of excuses for crime, that somehow if you committed a crime it wasn't your fault, it was society's fault. And so the combination of those two things we think sends a very powerful message from the Parliament to the judiciary that we want to have greater consequences for crime and, in effect, tougher sentences. Now, people will sort of go on about, well, the independence of the judiciary and so forth. No, Parliament sets the sentencing framework. And it is perfectly within the rights of Parliament to set minimum sentences or mandatory sentences. The process, the tradition in this country has been to set maximum sentences and allow judicial discretion, with the exception of murder and where there's a minimum mandatory. And so our view is that it is actually, given that we've made substantial changes in this area, we've limited the amount of discounts, we've brought back 3 strikes, we've done away with cultural reports. Our view is that that will have a significant impact and achieve a lot. It's only really just coming into consideration for cases now that the law has been passed, come into effect, and it applies to new cases. If we find in a few years' time that that message still isn't getting through, well then the next cab offer of the rank is to consider more minimum sentences, but we haven't got to that point yet. I think it's worthwhile assessing the progress that we've made with the changes that we've made before going to a minimum sentences regime, which is a very fundamental change to our sentencing framework as a whole. So that's a difference of opinion, but we're all very determined to restore real consequences for crime. We've made real progress, and this is another step in that part.
Honourable Dr Duncan Webb.
Thank you, Mr Chair, and I thank the Minister for acknowledging the work that was done in Select Committee by me and others around making sure that this creation of this offence didn't create an anomaly whereby if you weren't convicted of it, you got off scot-free, even though it would meet the test for culpable homicide as by manslaughter. And I see the Minister has tidied that up by putting it in the right place in his amendment paper, and we'll support that amendment paper, although to be clear, because it improves something which is pretty bad, so it just makes it slightly less bad. For that reason, we'll support the amendment paper, but we certainly don't support this bill. And I want to explain why we don't support the coward punch provisions. Any death, and we heard some terrible and sad and tragic stories of deaths caused by punches. Any death which is caused by an illegal act needs the most serious response of the law. But there's fundamentally 2 reasons why coward punches don't work. One is, why is it more heinous for a person to be killed by an unexpected strike to the head than an unexpected push to the chest? Because both of those things cause deaths. Most coward punches, the death is caused by the head striking the ground. Why is it more heinous for a coward punch, 2 burly people who, in the recent case out of Wellington, was 2 fairly hefty people having a dispute and an unexpected punch, than some huge guy who threatens a smaller person and says, I'm going to punch you in the head, and does so. It's not a coward punch, but it's heinous and requires a fierce response by the law. Why is a coward punch more heinous than a man in a domestic violence situation who hits his spouse and she knew it was coming? They are all heinous deaths, and we shouldn't be separating out one kind as requiring a special response. They should all be treated as most serious crimes. And if many of them might reach the threshold for murder, if they were reckless as to whether death ensued or not, but if in fact that was not contemplated and they didn't think that they would cause death, then manslaughter is the right conviction and the law should treat it appropriately. The other problem is this: you've created an incoherent offence where the prosecutor has to prove a list of things. I can imagine the courts spending hours discussing where the neck starts and finishes. What is it for it to be unexpected? These kinds of evidential debates are entirely unhelpful. What the real question is did that person, assault the other, and were they reckless as to death or not? And the wider context. What was the disparity of power between those persons? And we should equip the judges, and I accept some of the concerns around the sentences that have been imposed. But what we don't want to do is to create an absolutely incoherent offence that makes no sense internally, because there's no real difference between a punch to the head and a kick to the chest when death ensues. And there's no difference between saying, I'm going to whack you and doing so to a small person, and slapping someone in the face unexpectedly. Because just remember, a slap, which someone didn't expect, meets this test if someone then falls over, strikes their head and dies. And that's the other reason why, we certainly won't be supporting any minimum sentencing, because it makes a nonsense of how the offence would work. So we will not be supporting, we don't support these coward punch rules.
Dr. Lawrence Zunard.
Thank you, Mr. Chair. I just want to first, because this is my first call from my previous one, I do have two quick ones that touch on in previous section. Very succinct. Just clause 16, new 98D replaced. I just want to check if, to the Minister, 98D1, subsection 1A, 1B, and subsection 3A, if those lists are exhaustive. That's all, if the Minister wouldn't mind just checking. I will now move on to subpart 4. But can I also just check with you, Mr. Chair? In the Minister's Amendment 660, there's a replacement for clause 19A, which is now in subpart 1A of part 2. It is in a separate part, but it is integral to this section. Can I just check with the Chair if it's okay for us to also discuss that particular bit in this discussion as part of part A?
Yes, it is. Okay. You'll obviously relate why.
Yes, absolutely. I do want to start by also kind of contributing towards some of the other amendments, and also in response to what the Minister has said. Again, this probably was one of the more fraught aspect of this bill during Select Committee stage. And I think it is important also, following on from the contribution by the Honourable Dr. Duncan Webb, is to remind the House as well that, number one, when you're looking at, with any sort of manslaughter or murder under the Crimes Act, what we are looking at is both the actus reus, the mens rea, and co-occurrence. The mens rea component specifically, if you're looking at section 167, if you look at subsection C and D, is that it does address murder in the context of certain recklessness and also the use of object. For example, if you hit someone with a vehicle. So I think if there were any ounce of intention that was determined by the court and by the judge and jury of this section, that the strike to the head or neck was done intentionally, there is grounds that it would be considered murder as opposed to manslaughter. I do also acknowledge what the Minister has mentioned before, that there have been other changes, whether it is the sentencing amendment bill or the repeal of the reinstatement of the three-strike legislation, that we are going to be seeing some of the changes But I think it's also important, I guess, for the House to remember that while the Minister has said that cultural reports are something that has been defunded or given lower priority, under the Sentencing Amendment Bill, now Sentencing Amendment Act, you can pay your way to go beyond the 40% threshold. So we're still not really looking at the case of equity there. One of the questions I have for 19, and particularly the new section 117A, and again, this follows from the contribution by the Honourable Dr. Duncan Webb, is how would this be interpreted in a court of law? So I guess particularly if the Minister wouldn't mind giving some examples under 171A subsection 1 of what is the expected, what is the expectation, I guess, around the interpretation of circumstances? And what then are we looking at when we say limited or no opportunity? Again, some of those can be considered subjective. Are we looking at reasonable person test, or are we looking at a specific, I guess, you know, when we're looking at the test for that, are we looking at a subjective test? Are we looking at an objective test? That's incredibly important, again, when it comes to criminal law. That's relevant to this section as well. I think I would leave that question there, but just noting to the Chair that obviously we'll be moving on to 19A, and then I mentioned the Minister's amendment in 660 on Criminal Procedures Act.
Governor Bellich.
Thank you, Mr. Chair. And following on from the contributions around the House on this harm by strike to the head or neck, I just had some kind of technical questions for the Minister in relation to where he has landed on these particular provisions. So we're aware of the issues surrounding the drafting of this, and the compromise that has been reached, and this was inserted from Select Committee, is the alternative verdict of manslaughter that's inserted in 19A. And I was present at the Select Committee, and I'm aware of how we ended up getting to this place. But I do think it is important, even though there has been a attempt to try and get around the issue, that I think fundamentally the issue that the officials were advising against was that we did not have the correct primary legislation to put this particular offence in. And so that has led to some legislative gymnastics, awkwardly trying to squeeze this puzzle piece into a different puzzle, which is the wrong puzzle for this particular piece in the Crimes Act. However, we're aware of the history, we know that it's here. It's also important that it's workable in terms of the way that it will be applied. And so in the alternative verdict of manslaughter, we have a situation where we were clearly advised that the components of the coward punch provisions in relation to a situation where a death had occurred, and we acknowledge that there's a grievous bodily harm offence which was less problematic in terms of where it fitted into the legislation. The advice was we were in a situation, and this has been very influential on our decision not to support this part of the Act, was that there would be, it was so unworkable, there was likely to be fewer convictions when this was tried. And so that has led to the alternative verdict of manslaughter being able to be used in those circumstances. But from a practical perspective, I wonder if the Minister could, and appreciate that this is a technical aspect of the bill, I know he has officials here to assist him, how is this going to be communicated and work in practicality when there is a coward punch offence, manslaughter, or when 171A, which is inserted in section 19, when this is utilised as a primary offence, how will this be communicated to defendants and their representatives that they must, as part of the trial process, also prepare a defence for manslaughter whilst being charged with the offence under 171A. So from a defendant's perspective, and it's important, even though our sympathies are not with a defendant, and obviously but they should be innocent until proven guilty, and what they are facing is a dual charge, which does at times occur in criminal law, of manslaughter to strike or head or neck, or manslaughter as exists in the current law. Now, my question is that correct? Will it be necessary for this to be flagged when they are first charged with an offence? And I think that is important because that's they need to have clarity around the offences that they are actually defending. And will there be guidance around this to prosecutors? The fact that it's most likely necessary that when you charge under 171A, you will also have to charge a alternative charge of manslaughter at the same time, because otherwise it's going to be very difficult from a justice perspective for this to actually work when it is implemented. And appreciate that this might not have been the Minister's ideal situation, or maybe it is, but I would appreciate some workability advice on how this will occur.
Well, just look, I'm advised that it's an operational matter for the courts and the Ministry of Justice to help people navigate their way through this process, and it's a common issue with alternative charges, which is, does occur elsewhere in the law. In terms of for a defendant knowing that they need to prepare for a general manslaughter charge as well, my assumption is that they will have a defence lawyer, and the defence lawyer will read the legislation, and the legislation makes it clear that if a prosecution is brought against this coward's punch causing death, then the jury could also consider a general manslaughter charge. So, I mean, I think it's pretty basic in that regard.
Dr. Lawrence.
Thank you, Mr. Chair, and thank you for the responses. I do think that some of the broader guideline aspect that we asked previously is actually important for us now. I think even in the simplest way, that any criminal trials or any murder or manslaughter trials involving this, that there is some sort of additional guidance for the court and for the juries to get some sort of ministerial intent on the expectations of this section, with the example I gave before on whether the limited or no opportunity in 171A1 is an objective test or a subjective test. But I think the question that Camilla Bellich raised is a really important one, because would there be an expectation that a person needs to be charged for both a manslaughter by strike to head or neck in the new section 171A, as well as manslaughter under, I believe, let me just double check, 171. How would that work in practice? I think they need to have two charges, because the issue is, if there isn't, and the person gets acquitted for one of them, then are we then seeing what the minister has put in his amendment paper 660 for amendment to Criminal Procedures Act? Then there is this automatic manslaughter provision that then needs to be considered. Are they going to be considered concurrently as a result. So I'm looking at the page 3 of the Minister's Amendment 660, Clause 28B, which is essentially a repackage of the existing Clause 19A in this bill, but just being put into a more appropriate legislation, consequential legislation in the Criminal Procedures Act as opposed to in the Crimes Act. That being one of the questions, but again, if that is going to be the case, how would there be the expectation for the court to work through some of these considerations? Now, I do want to kind of touch on Clause 20 now, just in terms of the wounding with intent by strike to the head or neck. Noting that this is, in terms of the wording, is no different from what we're currently seeing in Section 188 of the Crimes Act, particularly subsection 1 and 2 of the Crimes Act. I just want to check with Dan, the Minister, considering that we don't have a similar provision as what we're seeing in what is formerly Section Clause 19A, now in the Part 2 Criminal Procedures Act 28B, are there an expectation as well that a person needs to be charged under both 188A as well as 188? Again, if any person is acquitted from 188A and they're not charged under 188, then they have to be acquitted overall. Otherwise, we run into the issues of double jeopardy. So I want to check with that with the Minister initially, because again, for Clause 20, we don't see the similar remedial provisions that we're currently seeing in both 19A and also the Amendment Paper 660 28B. Just want to check.
Honourable Minister.
In terms of the question of limited or no opportunity to defend themselves, the definition, look, that is new wording, and my advice is the courts will determine how to apply it. In terms of being charged with one or two offences, my advice is that you be charged with one and then it drops to the other if that is applicable. So the charge of coward's punch, and then it can drop to a general manslaughter charge.
Honourable Dr. Duncan Webb.
Thank you, Mr. Chair. Of course, I want to move on to the first responders shortly, probably in this call, but it's interesting that the Minister talked about it dropping from this manslaughter by strike to head or neck down to manslaughter, because they're in fact both simply manslaughter with the same sentencing, and which is another reason why this manslaughter by strike to the head or neck offence makes no sense, because it's just manslaughter. It's just a variety of manslaughter with exactly the same sentencing regime as manslaughter simpliciter, if you like. And so I can understand why his coalition partners are scratching their heads as to why it's here at all in making the arguments that they are making. I don't want to talk about that particular part of the bill anymore, but I do want to just look at offences against first responders and corrections officers. And I see the Minister in his amendment paper, I'm not sure he talked about it, but in his amendment paper he has expanded the definition of corrections officer substantially, and it also included persons under the control of a corrections officer as an additional definition, because it feeds back into what a corrections officer is. There seems to be overcomplicating this substantially, because and it's a long definition in his amendment paper. I'd be keen to understand why the first definition, which is simply the meaning given to a corrections officer in Section 3.1 of the Corrections Act 2004, why exactly that didn't work. The other thing I'd like to just ask about this is, because we've got these first responders and corrections officers, and what we've done, or what has been done, is essentially a closed list of constable, authorised person in the Policing Act, ambulance, first aid or paramedic, and fire and emergency and corrections officers. We had long discussions about who else should be involved in that, because there are a number of other people. Surf lifesavers came up. Now, they're not statutory officers, but a statutory officer that did come up that wasn't included, although there was a strong argument put they should, was Māori wardens, who have statutory powers and are statutorily appointed, and do in fact respond to disorder events, often on marae and Māori gatherings. So I'd be interested to understand that a corrections officer definition and why the existing one, which is very simple and elegant, didn't work, but also why the Minister wasn't eager, and if he would consider expanding, in fact, the definition, if we're going to have first responders, to actually looking at some of these other people, such as Māori wardens, who exercise statutory powers in specified situations and are equally subject to the kind of risks that we're looking at here.
Kawana Balich.
Thank you, Mr. Chair. And just for clarity, I know that we're kind of moving past the coward punch section now, and I do have some questions on the next sub-part. But it would be good to just hear from the Minister some clarity around just definitively that whether or not he will be supporting the amendments from his government colleagues from the ACT and New Zealand First Party. I didn't quite catch that when we were discussing that before. But I do have some questions around corrections officers, and the Minister has, again, there has been a relatively substantive amendment put to this. So I think we're at a stage, Mr. Chair, where we have an amendment that has been put in, that was put in at Select Committee for the Part 2, which we will discuss later. We've got amendments from all government parties, actually, and we've got a new amendment which adds in corrections officers. Now, this is not a part of the bill that we object to because we understand that there are jobs that can have innate risk associated with them, and sometimes those people will go into dangerous situations and they won't have a choice. Many of us will have an instinct to avoid a dangerous situation. Well, if you're a volunteer, if you're a firefighter, or if you're an ambulance officer, if you're a paramedic, your job is to ignore those warning signs and actually rush in, and sometimes that can be physical threats from disasters, fires, for example, accidents, or it can be threats from dangerous individuals. But as my colleague Dr. Duncan Webb said, there was not a fulsome discussion on the extent to which this right would put in place. One particularly dangerous, particularly important, particularly undervalued job is that of a mental health nurse. And those people walk into work every single day and are confronted with some of our most vulnerable people who can act in a way which is unpredictable, and they must care for those people, and those people will not be convicted if they attack them. And they, so in the situation where there is sufficient mens rea for those types of attack, there are other jobs which are equally important to the safety of New Zealanders than those which are listed here, and that's not to undermine at all the important work that those listed here do, and obviously corrections officers are one of those that the Minister has sought to put in through his amendment paper. So my specific questions that I wanted to understand in these particular clauses that have been put forward, there is talk in the, I think it might be in the RIS, around the fact that people who are volunteers would be covered. I think that that is correct, that is the intention. It would be good to have for the Hansard that articulation, if that in fact is correct, that volunteers acting in these roles are also covered. The other question I have is, we have specifically in clause 23(3) people who would not be considered volunteers necessarily, in the sense that we know that volunteer firefighters have a very specific role and they're considered to be volunteer firefighters, and they do a large amount of the fire and emergency work throughout New Zealand. But we have, I think, probably a step down, maybe not a step down, but a step to the sideways, a different category of people in 23(3) who are members of the public, really. So I think, well, that's my question for the Minister. We have any person acting in the aid of a constable is also covered in relation to these provisions, and they are also protected by these aggravated assault provisions. So I want to know to what extent volunteers are covered, if in fact it's the Minister's intention, as provided in the information, that formal volunteers are covered, and also people who are assisting in the course of a first response type of situation, if they would also be covered.
Lawrence. Oh, sorry, the Honourable Minister.
Thank you for the comments and questions in relation to this piece of legislation. And so what we're trying to do here is recognise the specific circumstances of first responders who, on behalf of the rest of New Zealanders, go towards a dangerous situation on behalf of the rest of the community, and specific offences here against those people who attack them in the course of them doing it. Now, a question was asked around corrections officer and the detailed description that we've included in relation to that, and the definition is long, primarily because there is a wide variety of frontline corrections roles, and so that is a reflection of that. A question was asked around volunteers. Yes, the definition of first responder intended to capture those emergency service providers. It includes volunteer fighters as well as volunteers and students on educational placements as well. So that's pretty important as well. Now, of course, many people over the course of the exercise have raised other groups of people who are sometimes assaulted in their work. And ask why they're not included in this. And I absolutely understand those. Everybody will make a case, and we don't in any way disparage the efforts and the risks taken by any New Zealanders, whether they be school teachers or health professionals. But all I can say is that through this process we have particularly identified firefighters, police, ambulance and corrections officers who routinely are dealing, and there's been many instances where they have been attacked, and so that is where we've started this conversation.
Honourable Casey Costello.
Thank you, Madam Chair. I appreciate the opportunity to take the call. This is again an opportunity for me to speak in this part around amendment paper that is in my name, number 649. And again, this is a reflection of the New Zealand First position around the seriousness of this offence, and it is why we included specifically in our coalition agreement minimum mandatory prison sentence, because of the seriousness of the circumstances of the offences of first responders. I think it was important to highlight that in this discussion, this isn't about who is more important or less important when it comes to crime. It's the nature of first responders that we are pushing them into these situations, and this is what we're trying to recognise, is this concept that those that we are, and you will hear frequently from ambulance officers that they are dealing with situations that are volatile, emotions are raw, and they are treated in some circumstances appallingly. But this is about sending a clear message that these individuals that we ask to do so much on behalf of our communities are going to be protected at a higher level. So the amendment that we're putting forward is actually just to insert at least 6 months, but not exceeding 5 years, into the new section 193.3. And again, we recognise the seriousness of minimum mandatory sentences. We do acknowledge that that is a big decision for any court to make, as to say this. But again, this is about sending a clear message to those, the tolerance level, and having been in those positions where you're assaulted and you do finally get to court, there is a sense within the court environment that that our first responders, can expect this, that this is the nature of the work that you do, that somehow our first responders should be thicker skinned or tougher or more able to deal with it. What we're asking here is for our courts and our system to say to those who think about it, this is the proviso, this is the thing that we want to be widely communicated and recognised. And this is why the amendment is so important to New Zealand First around making sure that our first responders are treated as a different category, that this is, we're asking so much of you, it's not unreasonable that they ask something of us to ensure that level of protection is applied to them. And I would appreciate the Minister's consideration on those matters.
Dr. Lawrence Yunnan.
I just want to follow up from the response from the Minister regarding a previous section, section 19 and 20. Thank you, Minister, for clarifying that if it's not charged under 19, it will now automatically be charged under the second one, which is Criminal Procedures Act, in Minister's Amendment Paper 660. But just want to see if the Minister has a response to my question around Clause 20, because Clause 20 doesn't have the same level of provisions as we see with Clause 19, where if one doesn't go through, it defaults to a second. So I wondered if the Minister had any consideration around if a person isn't charged under 188A, they will be charged under either 188 subclause 1 or subclause 2 instead. Otherwise, a person will need to be charged for both crimes in order for there to be, I guess, the avoidance of a loophole with acquittal. Now, on to subpart 5. This is an area that we also think it is important, and the Minister has clarified in terms of some of the other groups. But just also noting in terms of the Minister's definition for first, I believe, front line, and I think that's a key aspect. I want to check with the Minister in terms of, so Section 2 amended, this is C, Roman numeral 2, which is specifically around designated services under the Fire and Emergency New Zealand Act. Now, those designated services are specifically with regards to fence, but I want to check with the Minister that would the Minister foresee something like this being covered for example, for defence forces and for civil defence as well in the event of an emergency, because that's not covered under the definition of designated services. Or is there another provision within the Fire and Emergency New Zealand Act 2017 that naturally covers for that?
I'm sorry to interrupt the member, but the time has come for me to report progress. We have a special debate this morning, so well, slightly into the afternoon.
have someone coming. Otherwise, Greg could report back to me and it won't compromise his position in the debate. No, I was going to say you could report back to me. That wouldn't compromise. You can't. Here we go.
The House is resumed.
Madam Speaker, the committee has considered the Employment Leave Bill and reports it without amendment. The committee also has considered the Crimes Amendment Bill and reports that it has made progress on the bill. The committee has also considered the English Language Bill and reports that it has made no progress on the bill. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it. The Employment Leave Bill is set down for third reading next sitting day. The Crimes Amendment Bill is set down for further consideration in committee next sitting day. The English Language Bill is set down for consideration in committee next sitting day. I call on Government Order of the Day number 6. No? Got a special debate. Sorry, a different sheet. Members, we come now to the debate on petitions arranged by the Business Committee under Standing Order 80. Would some honourable member here to move that the House take note of the petitions that have been considered by the Select Committees in the 54th Parliament?
I so move. Madam Speaker.
Greg O'Connor.
Thank you, Madam Speaker. I rise as the chairman of the omnipotent Petitions Committee. The Petitions Committee was a creation of the last Parliament. I remember being on select committees where petitions were these things that arrived and sat around, usually at the end of the agenda, because no one really knew what to do with them. They were really quite a specialised subject and they required quite a bit of work. The whole petitions process is a very important part of our democracy. It's the way that our citizens are able to bring matters, and I might say a wide variety of matters, a large, broad range of matters, to the attention of the Parliament. And of course, when each of these petitions were being dealt with as a subject matter specialist, as they were on each of the committees, they got a varied approach, a varied response, and probably most of the submitters would have gone away not particularly satisfied they'd been well heard. So the decision in the last Parliament to form a petitions committee was not only good for the select committees, but it also allowed a certain amount of expertise to be developed around the petitions committee. So the petitions committee now, what we endeavour to do, we've got a very, very good committee at the moment, and we endeavour, when these petitions arrive, to look at them outside the political sphere, outside our parties and caucus sphere, and to see just what it is that the petitioner really wants and what it is the policy issue in particular that we can address and then respond to and perhaps send it off to the relevant minister and certainly back to Parliament and get a response where one is called for. Of course, like a lot of our work, there is a variety, and the, shall we say, the thought that's gone into some of these petitions does vary. Some of the petitions that arrive on our desk, Madam Speaker, really do cause us to wonder why this hasn't arrived earlier. Many of the private members' bills, now the members' bills that have arrived on the floor of the House have originated from petitions. And there's two particular petitions that I look at that really cover the range of petitions. We have had a considerable number. We've had 155 petitions that were reported back by the Petitions Committee. 69 have been referred to ministers for a response, and we currently have 109 petitions under active consideration by the Petitions Committee. So as you'll see, there's quite a range of topics. So rather than go through each of these, and my fellow members of the Petitions Committee will be addressing some of the more specialised topics there. And also, before I just go into this, I have to say we're very well clerked as a committee too. We've had Tui Head, Isabel Tannock, and currently Anna Platten, who ensure that we and their team ensure that we do get the best of work and the best of attention. So just a couple of petitions of particular, I'd say two petitions that we've dealt with that are at the range of the petitions we received. One is a petition by Alistair Rees calling for a recognition of the oral agreement as part of the Treaty of Waitangi. Now, this is a very interesting petition. Now, those who understand their history, and we all should understand plenty about the Treaty of Waitangi, one of the fourth unwritten clause of and recognised clause of the treaty is the right to religious freedom. The story around that was that Bishop Pompalia was a Catholic, and he felt, and there was a fear that at the time, and you remember in the 1840s, at that time, there was a lot of religious warfare and certainly divisions in taking place in Europe. And New Zealand in many ways was considered that it might be better to keep it a Catholic-free zone. Well, of course, the French had designs on New Zealand at the time. French, being Catholic, would have realised that may not have augured well. So Bishop Pompalia petitioned Mr Hobson and Reverend Williams, and there was an agreement at the time that we would have religious freedom, but it was never enshrined, it was never written down. So this is, the petitioner was to recognise the oral agreement as part of the Treaty of Waitangi and recommend to the government that a policy process be initiated that considers ways in which the oral agreement of Waitangi could be formally recognised and encourages the government to consider using public engagement tools such as deliberative democracy on the part of the process. Tu Kamatua had actually originated this from Ngāti Ranganui, Patrick Nicholas and Huikakahu Kawe. Both had been were deceased, so the petition was picked up by Dr Alistair Rees. The referred to the oral exchange between Governor William Hobson and Bishop Pompalia at Waitangi on the 6th of February, referred to as the oral agreement. So we heard some very interesting submitters. We had submitters from the Anglican Church, from the Presbyterian and from the Catholic Church who came with the petitioner, and what was particularly clear was that there was agreement among the churches that this is something that they would all be happy to have addressed, that certainly in our Bill of Rights we have the right of religious freedom, so of course it made sense that that should also be included in the treaty. However, this is how we like to work as a committee. We then heard from who is someone who has got a good constitutional view on this, and we got Sir Geoffrey Palmer in. Well, Sir Geoffrey Palmer, I'd have to say, I've sat on that committee for some time. It would be one of the more interesting of the submissions we have heard. And anyone who's heard Sir Geoffrey Palmer will know that he was in his element there. It was part of our history, part of our constitution. And again, noting that time is moving on, that he didn't recommend at the end, after some great discussions around the committee, it wasn't as recommended that we'll continue with the process of having a written version of this to open that, my words not his, can of worms at this stage when even within this House there is the treaty can be somewhat contentious. It was best left alone, and that he himself, of course, having being the author of the Bill of Rights, pointed out we do have the right of religious freedom anyway. But again, I bring that as an example of just the type of work we're able to do as a committee. On the other hand, another one, we've had a petition from Zane Allen to ban geoengineering and weather modification in New Zealand. This is the good old chemtrails. And every MP here will have had someone coming into their electorate office to talk about banning chemtrails. Well, the committee, rather than just deal with that, we thought, well, what is this all about? Why is this there? And I hesitate to use the word conspiracy theory, but why is it that around New Zealand there are those who believe they look into the sky and when they see the Air New Zealand 530 from Auckland to Wellington flying over Mount Ruapehu, I mean, there's this beautiful vapour trail behind it. They believe it's a chemtrail. So what we did, we got one of our local academics in to say, what is this? Where does this arise from? It arose from, like so much does, from the United States. And as you might imagine, again, where my time is coming to an end, that we didn't recommend that any action be taken on this. I just look at those two particular petitions and just finish by saying I think the way that the petitions are dealt with in this House, I did make submissions to the Australian Federal Parliament they have a petitions committee. They largely don't hear from their citizens. They deal with the petitions on their merits. And they are very much lost in the system. So I think we deal with these, the way we deal with the petitions, the system we have here is a very good one, and I would certainly be recommending the Petitions Committee continue. Thank you, Madam Speaker.
Thank you. The next call, I'm advised, is a split call. Greg Fleming.
I te manga te whare tuatahi. He mihi tēnei ki tō mātou tia mana o te committee kia Greg Fleming. He honore nui ki au te noho hei tia mana tuarua I tōna taha. Serving as your Deputy Chair, Sir, Mr Greg O'Connor, has been both a privilege and a genuine pleasure. Can I also mihi briefly to the clerks represented here today, to Benji, Anna, Kita, who else is there? Lisa and Mary. Awesome to see you guys. And also shout out to Izzy and Tui. We have, as Greg said previously, we have been wonderfully served these last 2.5, coming up 3 years. As our Chair has just reflected, Madam Speaker, this committee has considered an extraordinary range of issues over this Parliament. We've done so with cross-party rigour, candour, respect and thankfully no shortage of good humour. In the interest of time, and because Greg O'Connor is not in your chair, I'm going to actually read my speech to be very precise. A number of petitions have stayed with me long after the hearings ended, none more so than the petition from the Problem Gambling Foundation. So I'm going to spend the rest of my time explaining why the committee reached the recommendation that we did and why I believe Parliament should take up that challenge in future Parliaments. The committee heard compelling evidence and read thoughtful submissions. We reached a clear conclusion. I'll read it here. We agree with the petitioner that the current regulatory settings are inadequate, and we are concerned that there are insufficient protections in place for vulnerable populations. With this in mind, we recommend that the government review the regulatory settings around gambling advertising in New Zealand. Madam Speaker, I support that recommendation wholeheartedly. Earlier this week, as I was heading to the airport, I mentioned to my youngest son that I'd be speaking today about gambling advertising. Like most 17-year-olds, he's not rigorously engaged with my parliamentary work, but on this occasion he leaned in. Dad, over half of the ads I receive on YouTube are for Betcha. And for those members who don't know, that's the TAB's betting app targeting 18 to 29-year-olds. Think about that for a moment. Here's a young man who isn't even legally allowed to gamble, yet gambling advertising has become so normal it's simply part of what he now sees online. The reality is that gambling no longer waits for adults to seek it out. Increasingly, it seeks out our young people. It arrives through sport, through gaming, through social media, through the phone in a teenager's pocket. Advertising is the thread that stitches gambling into all of those parts of a young person's life until it simply feels normal. It's not good. The evidence that we heard as a committee was consistent. Exposure to gambling advertising makes gambling appear more normal, creates more positive attitudes towards it, and increases the likelihood that people will gamble. One New Zealand study here in Wellington actually placed wearable cameras on children aged 11 to 13. The cameras took a photograph every 7 seconds over 4 days. Those children were exposed to gambling marketing on average of 7 times every day. And that didn't even include what they were seeing online. What is being advertised today is a world away from the gambling many of us grew up with. It isn't a lotto ticket bought on a Saturday and checked on a Sunday. Today's products are immediate. You can place a bet, have it settled and place another within seconds. They're designed to be fast, they're designed to be repeated, and they're designed to keep people engaged. They're designed to make people addicts. What's even more concerning is that many children are learning the mechanics of gambling long before they ever place a bet. Randomised rewards, loot boxes and skins are now a normal part of many of the games they play. The evidence that we heard showed that spending on those features is associated with a greater likelihood of gambling later in life. If gambling has changed this much, then surely our approach to gambling advertising needs to change too. We've recently developed detailed advertising rules for licensed online casino operators, but outside that new regime, lotto, racing and sports betting largely sit under a voluntary advertising standards authority code that relies on complaints after an advertisement has already run. That may once have been enough. I do not believe it is any longer. Parliament has recognised the need to protect children in other parts of the online world. We've debated social media. We've acted on mobile phones in schools. We understand that technology shapes behaviour. Surely gambling advertising deserves that same careful attention. During New Zealand's opening World Cup match last month, children across the country were watching in classrooms and homes alike, celebrating a moment they'd waited years to see. Then came the advertising break. Gambling promotions, inducements, the unmistakable message that betting was simply part of enjoying the game. Every one of those advertisements complied with the current rules. That's precisely the point. The rules themselves are no longer good enough. If the evidence presented to the committee teaches us anything, it's this. Gambling is changing faster than our laws are. It's now up to Parliament to decide whether our protections should change with it. For as long as I have the privilege of serving in this House, Madam Speaker, I'll continue advocating for that review and for stronger protections that better reflect the digital world our young people are growing up in. The Petitions Committee issued to Parliament a clear challenge. I believe it's one we should accept. Thank you.
Thank you. I just would make the comment, in terms of reading speeches, there was a lot of recommendations and quotes in there. It's when people don't understand their speech, which that member did understand the speech and used those recommendations and quotes to get the message across. So I deem that it's fine. Honourable Scott Simpson.
Thank you, Madam Speaker. Madam Speaker, it was a cold winter's night on Thursday the 23rd of July 2024 when ACT Party MP and myself were in the Katikati War Memorial Hall, and we were with nearly 400 local residents who were scared, worried and feeling angry about NZTA's proposal to put wire mesh barriers down a significant length of State Highway 2 between Katikati and Aotearoa. And on that very night, we had some good news. We were able to communicate to those interested community members that common sense had prevailed, and the board of NZTA had instructed their contractors to cease any further work on barrier installation. That was well received that night. We all went home reasonably pleased with the outcome, only to find that next morning, that very night, NZTA contractors had continued to install a barrier mesh that blocked off a right turn into Wright Road. Now, members in this chamber may say, well, what on earth has this got to do with petitions? Well, it's got to do with petitions because this is a serious local matter in my electorate that has been festering unresolved for 2 and a bit years. And there was considerable anger and outburst from the local community about it. A petition came to the Parliament in the name of Rachel Jarek and many of the residents who lived on Wright Road. It affects about 1,000 people. So this barrier, to give members some idea of the impact of it, means that now people wanting to turn in and out of this main road have to traverse an extra 6 kilometres
in order to get in and out of their residential, business or school road. Now, that adds enormous challenges for the people who have to do that. It adds time, it adds cost, it adds extra ruck mileage, it adds emissions, it adds danger if it's, for instance, an emergency vehicle, an ambulance, a fire brigade vehicle, or a police vehicle that needs to traverse that extra 6 kilometres. Now, the petition came to Parliament and it was actually sent by the Petitions Committee to the Transport Committee. And I have to say that the Transport Committee has done a very good and thorough job on investigating this petition. They are yet to deliberate. I understand that deliberation will occur very soon. And that will be a good thing. And I'm looking forward, as are the residents and citizens of Wright Road in my electorate. They're looking forward to it as well. But throughout this process, as I sat next to Rochelle, as she came to Wellington to make a submission on behalf of her neighbours and fellow citizens, there was an intransigent, arrogant, non-committal, unhelpful approach from officials at NZTA. And we were told repeatedly that this was a decision not made by officials at NZTA, but a decision made by the board of NZTA. And so what has happened in the subsequent time is that the barrier still exists, accidents have increased, risky U-turns are being done, and the lives of citizens have been impacted negatively. Now, I want to say to this House that often a design plan created on a screen in a cubicle at NZTA head office doesn't necessarily work in practice. And that NZTA, I think, have an absolute obligation to engage fulsomely, adequately and sensibly with local people who have local knowledge about local conditions. And that hasn't occurred in this case. In fact, it has been exactly the reverse. As I said, NZTA, in my view, have been intransigent in this. And so where we are at now is that these poor people are still having their lives impacted. Dangerous vehicle movements are occurring, accidents are occurring, and NZTA stubbornly refuse to reopen a right-hand turn into Wright Road. It's dangerous, it's unnecessary, it impacts negatively on people's lives, and it needs to change. And so, Madam Speaker, without wanting to overstate the case, and in the vein of former American President Ronald Reagan, when he was referencing the Berlin Wall, I say to the board of NZTA, take down your fence.
Celia Wade-Brown.
Thank you, Madam Speaker. It's been a pleasure to be on the Petitions Committee, and I would also like to acknowledge the Chair. He's open-minded, he draws on his extensive knowledge, and he doesn't close off options. We have some really good discussions and debates. What's practical? Can we deal with it? Are we the omnipotent committee that we like to think we are? Should it be most appropriately passed to a minister or a select committee? We would very rarely just say this is not relevant. I'd like to also, as Greg Fleming did, acknowledge the work of the staff, the work behind the scenes of the library, and most agencies and ministries produce great information when we ask. Some have to be prodded, unfortunately. Sometimes the ministers have to be prodded as well. We also ask input from a number of NGOs, whether it's the Law Society, the SPCA, or many other organisations. They are incredibly willing to share their information because they know that they will be listened to. But most of all, I'd like to thank the collective voice of Aotearoa New Zealand, the people who have got a good idea that they think we should take up. And of course, let's look at a little bit of history. The first and perhaps most famous petition was a women's suffrage petition in July, presented in July 1893. Now that was old tech, glued together pieces of paper. It was 270 metres long. Fortunately, we now get our petitions in electronic form. That was a dramatic and huge and important petition, and it resulted in action almost immediately. Presented in July, law change, September 1893. I would like to see a lot more attention to the public's view, whether it's small things or big things, where we haven't already settled into some calcified party positions that do not allow potential to be realised. I have really enjoyed working with Greg, with Paolo when he was here. Both Gregs. It does get confusing when both the chair and the deputy are called Greg, but we managed to get through that. I wanted to draw attention to a couple of interesting petitions. One was a petition that arose from a real, well, many of them arise from tragedies, from personal tragedies. People are trying to think, this awful thing happened to me, or I can't possibly afford to look after my disabled child or whatever and pay these fees. But one example came to us about can banks restrict payments for alcohol purchase for under 18s? We heard a lot of information. We also had some promises that things are being looked at, and one of my hopes is we decided we could not pursue legislative change at this time, but my goodness, if we don't see changes in operational work, I hope that future, the next term of Parliament will deal with that. I do want to take up something close to my heart. The committee in April 2026 reported back to this House on the fireworks ban. We had Animates, we had Suzanne, Raywin, 3 different petitions about banning private fireworks sales. We heard from Fire and Emergency New Zealand, we heard from the Ministry for the Environment, we heard from the SPCA. We were persuaded that the harm to animals, the danger to private property, the nuisance and unpredictability was just not worth that freedom. I thought we came to a really well-argued conclusion, and I am deeply disappointed that this government chose not to pursue this recommendation. So this is not just a valve to reduce political pressure. This is a real avenue for political change and responsiveness to the people of Aotearoa, New Zealand. Kia ora.
Cameron Luxon.
Speaker, this is a wonderful debate to take part in. The right to petition Parliament is a key right that we've had going back to Magna Carta. And in fact, New Zealand, it was from 1854 was our first petition to Parliament. It is an important institution. And I'm feel extremely privileged to be able to contribute to this debate with what remarks I have to say. Madam Speaker, in New Zealand, most New Zealanders assume that if you have a end-of-life directive, sometimes called a living will, sometimes called a do not resuscitate, an advanced care directive, or most recently in New Zealand with a petition to Parliament in the name of Louise Duffy petitioning for Barbie's bill. People assume that if you put your wishes down at the end of your days when a medical emergency or medical event happens to you that could end the natural course of somebody's life, that if you've put down your wishes, if you've put that in a way that is valid, that says, I wish to pass at this time, we assume, as Kiwis, that would be respected. We assume it rightfully. We think it because, for example, Section 11 of the Bill of Rights Act 1990 has in there, quote, this is the full section, right to refuse to undergo medical treatment. Everybody has the right to refuse to undergo any medical treatment. And so we rightfully think as Kiwis that if we've put our wishes forward, if we've made it clear what we would like to happen at the end of life, that if we wish to shuffle off this mortal coil and go gently into the good night, that we would be able to do so in accordance to our wishes. However, we had a petition come to this Parliament that was heard at the Petitions Committee, but it was also heard at the Health Select Committee, a committee which I'm a member of. And Louise Duffy came in and told us about the story of her mother's passing and the circumstances around that, where a living will, a advanced care directive was in place, but wasn't followed. Her mother Barbie was kept alive, and Louise, as the power of attorney, believes in a way that was not in accordance to her wishes. And Barbie spent, I think, 54 days later, before she passed, from a massive stroke, refusing fluids and refusing food to try and bring that suffering to an end. I heard this petition and was deeply affected because I thought of there was a beautiful photo of Louise's mother, Barbie, on the front cover, and you thought this happy, healthy, full of life lady had made her wishes clear and they weren't followed. And how can that be, that she had to, in the way she did so often, take control of her life in a way to end it, in a way that she trusted had been dealt with already previously? So, Madam Speaker, we heard this petition and I thought, what can I do to help? How is it that this can happen? And I got further into the topic and found out this is not a rare occurrence. It's not incredibly common, but it does happen. And New Zealanders, we just assume, as I say, because we've got these Bill of Rights Act and we've got these structures set up, that this is something that happens. But, Madam Speaker, there isn't a standardised template. There isn't one agency, one group that oversees this. There isn't a legislative framework describing how end-of-life advanced care directives should be managed, handled and carried through. There's legitimate reasons why this is a complicated method. I mean, there needs to be things like enabling medical professionals to make judgments, and so binding too hard is hard, and that's potentially why we've got into this position. But I think a petition like this coming to Parliament has really laid out a very important issue that most of us might not have to think about until a loved one or we require it. Madam Speaker, I think that this was an incredibly important thing to bring to Parliament. I'm very grateful that Louise Duffy has made us aware as a Parliament of this issue. We're coming towards the end of a term of Parliament, but I think that this is an important issue that we all should be aware of and that the next Parliament should be looking into. Thank you, Madam Speaker.
Just before I take the New Zealand First call, the Te Pāti Māori have asked to take the last call in this debate, so just indicating to National that whoever's next on your list will have the next call. Jenny Marcroft.
Thank you, Madam Speaker. Pleased to stand on behalf of New Zealand First to speak to this special petitions debate. You know, petitions are really important because the right to petition is a fundamental democratic right. Democracy, we know, it's happening this year, come November the 7th, at the ballot box, but it's not every 3 years that democracy happens. In fact, it can happen every day of the week because, you know, democracy is not a spectator sport. And so those petitions that come to Parliament, where those matters and those issues that are brought forward by the people makes those issues front and centre of the work we do as members of this House. It's one of the most direct ways that the public can access and bring forward those issues. Some may be historically significant, others may be just new issues bubbling to the surface. But it's a way that the people can speak directly to power. A formal petition, though, unlike something on the Facebook page, can't be scrolled across. It actually has to be acknowledged, it has to be processed and reviewed, and I'd like to acknowledge the work of the Petitions Committee under the Chair, Greg O'Connor, and the Deputy Chair as well, other Greg, for your work in taking quite a lot of work out of the rest of the committees, because in the past, when I was in the previous Parliament, I was a Member of Parliament. In the Health Committee, we looked at over 40 petitions through that 3-year period. So thank you for the work that you're doing as part of the committee. Now, everyday New Zealanders we probably know them, are the architects of some of the most and greatest social shifts in our history. The humble piece of paper with a signature upon it that passionate New Zealanders, passionate citizens have brought to the attention of this Parliament. And if you go back to 1893, as my colleague from across the House has mentioned already, the women's suffrage petition, 30,000 women and men, including my great-great-grandmother Edith Marcroft, signed that petition. It was on glued together pieces of papers. It was rolled out across Parliament's chamber. And that enabled the New Zealand to become the very first self-governing nation in the world to give women the vote. Votes for women. And we'll fast forward now to today, Madam Speaker. There have been a number of petitions, a couple of petitions this term. I'd like to speak to one in particular, that of Bob McCroskey on behalf of Family First. He wanted to define women as an adult human female in laws, public policies and legislation. And that petition was referred to the Minister. Sometimes the Petitions Committee deal with it, sometimes it goes to another committee, or it's referred to a Minister. And in this case, Bob's petition was referred to a Minister. There was 23,000, just over 23,000 signed that petition. And the petitioner said that the shift away from sex-based rights grounded in biological realities has profound implications for the rights of biological women, particularly in contexts such as women's sports and women's only spaces. The submission he put through said that legal and linguistic clarity on common sex-based terms with the establishment of sex-based definitions as legislation as a way of mitigating the risk to women's safety, privacy, equal opportunity and freedom of expression. And the government responded to that petition. And I'll just read a couple of pieces from the report. Gender-specific language is now infrequently used in legislation. For example, the term woman appears in only 30 public acts. However, it may be appropriate in certain policy contexts, in particular where legislation is concerned only or mainly with people of one gender, such as within the context of pregnancy or cervical screening. Someone needs to tell the Health Ministry that. But it wasn't the end of the road for Bob's petition. It led to a members' bill in my name, the Legislation Definitions of Woman and Man Amendment Bill, with the aim to anchor in law biological sex as a real and meaningful category, because replacing the historic meaning of woman, adult human female, with a new definition based on internal feelings has seen the term woman begin to lose its political, legal and moral weight. And the concerns that if that continues, the carefully constructed manipulation of the language while borrowing the historical force of the word woman will see the erasure of women as a political class. Madam Speaker, it is a privilege to speak on this particular special debate on petitions. Thank you, Madam Speaker.
Carl Bates.
Thank you, Madam Speaker. It was a privilege to serve on the Petitions Committee when I first entered this Parliament and work with Greg and other members across the House. I appreciate the fact that they both put up with me and the way in which I commented and drove forward work on petitions during that period. Having served on the committee, it is clearly an important part of the parliamentary process, and just want to acknowledge also the petition that came through on banning fireworks from a Wanganui constituent, Raywin, who came into my office, presented it to me, and I brought it down to Parliament. And I want to just acknowledge the work of the Petitions Committee after I left it, as they worked that petition through on behalf of my constituent, as I say, from Wanganui. However, I wanted to focus my contribution to this debate on outcomes that get achieved from petitions that go in front of this committee, and two in particular. One was on rates. Two petitions, one brought by Alan Peacock and another by Lee Hawkins, who talked about the cost of living pressures that have been created by one of the biggest increases that happens year in, year out through rates on families across New Zealand. Alan said in his petition that he told the committee he appreciates the tax cuts made by the government in 2024, but believes that the savings that were made for households are, and I quote, being eaten up by rates increases. And so I just wanted to acknowledge this particular petition, the way that the petitioner argued that councils need stronger incentives to focus on core services, on infrastructure spend, on being careful with ratepayer money, and on ensuring they deliver better value for ratepayers. It is simply not credible for councils and councillors to continue to take the view that they have no contribution to make in ensuring rates are maintained and grow at reasonable levels. So an outcome, in many ways, of this petition, it's fed into a position that the government took in late 2025, as acknowledged in the petition. It says in December 2025, the government announced that we will introduce legislation to cap council rates. It expects that there will be a transition period for councils to integrate caps into their long-term planning from 2027. It's one example of how this national-led government is continuing to fix the basics, Madam Speaker, and of course build the future as we ensure we get councils focused on core responsibilities today so that our communities can prosper, Madam Speaker, tomorrow. The second petition that I wanted to speak to is one that is currently in front of the Petitions Committee around paid parental leave by Shane Sharma. And so this particular petition seeks a minimum 12 weeks of paid parental leave, specifically for fathers and supporting partners. And as a father, Madam Speaker, of 3 children, with our youngest only just having celebrated her first birthday 2 weeks ago, I know personally how important those early weeks are and those early months are for families balancing new children in the household with demanding roles. So this particular petitioner is aiming to get specific parental leave for fathers and supporting parents. And while this petition is still working its way through the process, I did want to acknowledge that National has already taken a step towards not a direct implementation, Madam Speaker, of this particular petition, but we are committed to giving families more flexibility in how they access and use paid parental leave. We've announced that if re-elected, we'll extend paid parental leave to 30 weeks, which would help with this and ensure that ability for families that are different in different circumstances to use that leave in a way that is most appropriate for their family. It's all part of our focus on stronger families today, about fixing the basics, Madam Speaker, and building the future as we give parents the support and flexibility they need while helping build stronger families and caring communities across New Zealand.
Ingrid Leary.
This is a debate, Madam Speaker, and in that spirit I would like to commend Greg Fleming for his wonderful speech about online gambling harm advertising. I wonder whether his actions would be more powerful if he had crossed the floor and voted against his government for the bill I've just introduced, which not only opens online gambling harm, but also actually he specifically referred to loot boxes, which are not covered by the definition in Section 2. But Madam Speaker, I'm here today to talk about the petition of Chloe Hatch. Mental health counselling services in all primary and intermediate schools. And I think it's important that we look at the policy reason, as my colleague Greg O'Connor has said, the policy behind the petition. And the petitioner gives the reason that the mental health crisis is not only affecting teenagers and adults, but also children. Many children have to navigate huge life challenges, for example, abuse, bullying, grief at young ages, and cannot afford the counselling and support they need. I absolutely agree with that. And the crisis that the petitioner mentions is getting worse, and the children involved are getting younger and younger, particularly in our suicide statistics. We are seeing children in New Zealand as young as 12 that I'm aware of who have passed away. And in that vein, I would like to mention our family friend Shay Strickson-Pua, who died tragically, because when Shay passed away, he was worried that people wouldn't remember him, and I want to say his name in this House and acknowledge what a beautiful and outstanding young man he was, and what a fantastic artist and friend he was to our family. But I agree with the petitioner that schools are not only a place for mental health interventions, but actually they're a place for building resilience. And I refer now to the petition of Azana Mehmetaj about increasing funding for youth mental health services and reducing waiting times, because that petition hasn't yet been reported. It's open until September the 25th, which means people who are interested can actually go online now and exercise their democratic right to participate and support that petition. And that petition policy talks about wanting the government to increase funding for youth mental health services and reduce waiting times as well. And they give the reasons around many young people experiencing anxiety, depression and other mental health challenges, facing long waiting times before receiving support. Now, the Mental Health Commission has highlighted that. In fact, they've pivoted their work towards a focus on youth mental health, such is the extent of the crisis. The Mental Health Foundation has successfully petitioned the Minister in a less formal way, who has responded to say that he will start counting the wait times for young people to access mental health specialist services, and we're hearing the same message from the front line. The problem with only, though, measuring the wait times is that without measuring declined referrals, we're only getting half the picture. And that's incredibly important to understand, because the bar sometimes for accessing those specialist services can be raised when the services are not there, if there have been government cuts, as there have been under the last term of government. And so we need to make sure that whatever we're measuring doesn't gain the targets but actually tells the whole story. And I would urge the Minister to look at also measuring declined referrals across the motu so that we can really see what is happening with youth and young people. Another development has been really that contracts this week for mental health providers, many of them in the community are 4 weeks into not actually having contracts. That means no certainty of cash flow, inability to plan. I understand from a journalist who's been working with me on this is that some contracts, many of them won't get signed until November, and that leaves great uncertainty for our community providers. So not only that, the contracts have actually been made more centralised and are giving more power and authority to Health New Zealand. That is not going to serve our young people. So I would just urge people to have a look at the petitions page. There are some fantastic petitions there. I want to acknowledge the 2 young people who I've mentioned today who brought these petitions to the House, because they're absent in the chamber, and it's through these petitions we can bring their voice into our democratic process. And I want to say that we really need to have frontline services for acute youth mental health services that are currently not there, something I hope the next Parliament looks at. And I'd encourage everybody to sign the petition around youth mental health so we can continue to debate this.
Dean Bidwell.
Madam Speaker, it's a pleasure to talk to 3 petitions today that call for greater control of dogs laws in New Zealand and about what the government is doing. And as a dog owner myself, this issue is near and dear to my heart. In particular to one petitioner, Melinda McGregor, whose mum was attacked viciously by a dog. Her hand was severed with bites going through to her bone. The doctors agreed it was a vicious attack, and her mum was hospitalised for well over 2 weeks. She lives with dementia, and that attack dented her confidence and set her back. Despite this, the Waimakariri District Council told Melinda that they won't press charges against the dog owner because of her mum's dementia, and they felt that their case wouldn't stand up in court because she could not describe clearly what had happened. All the District Council did was ask for the dog to be desexed and to declassify it as dangerous. Despite the overwhelming evidence, despite the victim and perpetrator, in this instance, justice was denied. Madam Speaker, there are stories like this across New Zealand, and other petitioners like Tracy Ann Clark, who suffered vicious attacks from roaming dogs. Every year, 29,000 claims are made by ACC for dog-related injuries, and nearly half of them, 14,000, are due to dog bite injuries, with the remainder being injuries such as head trauma, fractures and scratches. Nearly 3,000 of these incidences are to children under the age of 14, and over 1,000 result in hospitalisations, and injuries and costs that mount up into the millions. And this House is no stranger to the impact of the effects of dog attacks, with 2 lives being lost in New Zealand in the last 16 months alone. One, Timothy Rolleston Bryan, and a 62-year-old Mahiata Te Rohi, who was fatally mauled by a pack of 3 dogs. Our message, Madam Speaker, is that Kiwis should feel safe in their community, and that we are concerned for the amount of serious dog attacks in this country, and that dog owners need to be held accountable for their dogs. And that is why, Madam Speaker, this government, the National Government, announced that we are reviewing the Dog Control Act. They're conducting a comprehensive review that these 3 submissions and petitions have clearly asked for, to crack down on roaming dogs and uncontrolled dogs. And I believe actually there is an update that is imminent from Minister of Local Government around something like I'm not allowed to announce, but something is coming out in the next 24 hours. I won't announce it, but it is clear, Madam Speaker, that before Christmas we want this review to be done, and next year we want to legislate for those changes. And because, Madam Speaker, that this is an outdated piece of legislation, and the review is covering everything from penalties, desexing obligations, enforcement powers, and guidelines for local authorities. I wish to thank the Petitions Select Committee for a comprehensive report, and also to the 3 petitioners, Change Dog Awareness Trust, Melinda McGregor and Tracy Ann Clark, who I actually helped sponsor this petition through Parliament. Madam Speaker, our message is very clear that dog owners need to take responsibility for their dog's actions. There needs to be greater enforcement powers, there needs to be greater clarity, so that everybody can feel safe when they're out in their own communities, walking their dogs and being a part of their community. It's all a part of this government's plan to fix the basics and to build a better, brighter and safer future for New Zealanders. I commend these 3 petitions to Parliament.
Oh, very good,
Honourable Phil Twyford.
At the end of last year, I accepted a petition from Stephen Lincoln of Botany Downs in East Auckland. And the petition called on the House of Representatives to urge the government to advocate that an ultimatum be given to the government of Israel to stop the genocide in Gaza and the West Bank, to allow UNRWA aid back into Gaza, and to negotiate the release of all captives. And I want to highlight Stephen Lincoln's petition today because the genocide in Gaza has been one of the biggest foreign policy issues of the last 3 years. It has touched so many people so deeply. And it's my view, it's the Labour Party view, and it's the petitioners' view too, I think, that the national-led coalition's response to Israel's genocide in Gaza has fallen well short of what many, many New Zealanders expected. Now, Stephen Lincoln's petition goes on to say there's evidence of genocide happening in Gaza, along with the illegal encroachment of settlements, displacing civilians and damaging infrastructure in the West Bank. The 1951 Convention on the Crime of Genocide has a binding treaty mandating signatories, of which New Zealand is one, to prevent and punish its perpetration. He goes on to say, we want the government to implement sanctions and expel the Israeli ambassador if the ultimatum is not actioned, and to support a UN-brokered two-state solution to ensure justice and peace. Now, if that had been the position of the government, it would have amounted to the kind of principled and ethical response that most New Zealanders wanted. But no, not this government, who by its muted response to the genocide and also by not extending diplomatic recognition to Palestine, even when Canada, the UK and Australia did, made New Zealand an outlier among the Western liberal democracies we normally line up with. In response to Stephen Lincoln's petition, the government laid out what it has done on this issue, condemned the terrorist attacks carried out by Hamas, urged Hamas to release hostages and designated Hamas as a terrorist entity in its entirety, called for a ceasefire in Gaza, repeatedly emphasised that all parties must abide by their international law obligations, $50 million in support of humanitarian relief, reiterated the two-state solution, and opposed the Israeli settlements in the occupied Palestinian territories. Now, in response, Stephen Lincoln said this: all these well-intended responses will not deter the Israeli government, emboldened by 2.5 years of no consequences following the never-ending revenge on Hamas and full support from the United States. He wrote, "You refer to the Israeli-Hamas conflict. There is no conflict of equals. The last rocket fired from Gaza was in early 2024. 7th of October 2023 was a terrorist attack, but the military occupation since 1967 has been brutal and deadly. You call for the release of Hamas hostages, now released, but silence on the more than 9,000 Palestinian prisoners. You label Hamas a terrorist group, but what about the genocide unleashed by the Israeli Defence Forces since October 2023? For the sake of completeness, let me set out the Labour Party's position on this issue. For a start, we recognise Israel's deliberate destruction of Gaza and the people of Gaza as a genocide. We would have had New Zealand intervene at South Africa's case against Israel at the International Court of Justice. We would have invited the Palestinian ambassador to present their credentials here. We would have, as we've been saying for the last year or more, legislated sanctions against Israel consistent with the International Court of Justice's opinion on its illegal occupation of the Palestinian territories. New Zealand has long put international law at the heart of our foreign policy. As a small country, we depend on it. But as the genocide unfolded in Gaza, the credibility of much of the West, including New Zealand, took a hammering because of our silence, because of our complicity. And Stephen Lincoln's petition, I believe, gave voice to many New Zealanders who agree.
E te whare today, I rise not simply to speak to a petition. It is the petition of H. Hakepa on behalf of Te Pāti Tangata Whenua, but to acknowledge Ms. Hakepa for the courage that she dare ask one simple question, and that is, why are Māori still being counted differently? Ms. Hakepa did what every citizen is encouraged to do. She researched, questioned, followed the law and scrutinised the numbers. After all that mahi, she reached the conclusion many Māori have felt for generations. The system isn't broken, it's working exactly as it was designed to work, to keep Māori representation behind Māori reality. The committee acknowledged the issue as complex. It acknowledged Māori children are not fully reflected in the current calculations. It acknowledged there are real concerns. And then it recommended doing absolutely nothing. That sums up this government perfectly. When Māori raise injustice, this government commissions a report. When Māori prove injustice, this government shelves the report. This petition asks Parliament to look honestly at how Māori electorates are calculated. It asks why general electorates are based on total population while Māori electorates are tied to adult role choice. It asks why the whakapapa of our pepe, our tamariki and our mokopuna somehow counts for less. These are not radical questions, they are constitutional questions that deserve constitutional answers. Instead, Māori are told to accept a formula that keeps us playing catch-up, Madam Speaker. Officials defend the mathematics, but maths isn't justice. You can have a perfectly calculated equation and still produce an unjust outcome. When Māori electorates represent significantly more people than general electorates, that's not equality. It is inequality with a calculator. The petitioner reminds us that when Māori seats were established in 1867, Māori were entitled to far more representation than the 4 seats that they received. More than 150 years later, here we are, still asking for fairness. Not because Māori haven't grown, not because Māori aren't participating, but because every time our people grow, the system finds another way to slow our representation down. Today, the government wants to delay it even further. A petition asks for fairer Māori representation and the government responds by making Māori wait longer. That's not a coincidence, that's a political choice. Te Pāti Māori, we have a different vision. We believe every person who identifies as Māori should be automatically enrolled on the Māori roll when they become eligible to vote. Not because we want to remove choice, but because Indigenous people should not have to opt into Indigenous representation. The right to enrol on the general roll should remain, but the constitutional default for Māori should be the Māori roll. Because whakapapa is not something you opt into, whakapapa is who you are. We also support reviewing electorate boundaries before every election so that representation keeps pace with the people. This petition and its response shows us that the establishment fears Māori political power. The current government have desperately tried to silence and disenfranchise Māori because they know that Te Iwi Māori will be deciding the 2026 election. Whānau, we have until midnight of 6th of August next Thursday to get on the Māori roll. The Māori roll is whakapapa in action. It shapes Māori representation. It strengthens Māori political power and it ensures more unapologetic Māori voices right here in Pāremata. Our tipuna did not fight for us to sit on the sidelines. They fought for our voice, our rights and for the future of our mokopuna, every single one of them who belong here to Aotearoa. The laws affecting our whenua, our reo, our whānau, our workers and our future are made here in Parliament. If we want a different future, we must exercise our political strength at the ballot box. When we get rid of this one-term government e te whānau and form a new government of our own, we will fix the Māori electorate calculation. If you are Māori, you have a choice, and that is take a tipuna action, make a mokopuna decision, and join the Māori roll.
The time for this debate has expired. The House stands adjourned until 2 p.m. today.